Hypocrisy.
Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. How's it going, guys? How is it going out there on the Rumble Land and the Odyssey Town? I hope you guys are having a great day. Good morning, whatever the hell it even is anymore. I don't even know. I don't even know what time of day it is. I don't know what time of life it is. It is, these trials. My body was not made for this. My body was not made for this. Okay. Let's figure this out as people filter in. The show has not really started in court yet, but it will very soon. I sent the link out to a couple people, but I need to send the link out to a couple more. Go away. So we'll do that just in case. He looks good, but also looks like he needs a drink. Well, yeah. The unfortunate thing is I will not be able to drown the pain of Darrell Brooks today, because if you do not know, if you didn't hear, don't remember, I will only be able to cover through about lunch today. Speaking of lunch, what's up, Legal Vices?
Hey, how you doing?
Pretty good, buddy.
Oh, better than me, it seems.
Why?
I'm having major StreamYard issues.
Yeah, I saw when you joined, it was like, yeah, I don't even see your camera. Your camera's stupid. Yeah. That's what it said. It was rude.
Oh, it did. There's something internal that's not working. Some stupid cookie or something that just keeps waiting and waiting and waiting. So as long as I'm here.
You're here. I can see you. I can hear you. That's
Can you feel me and taste me?
Well,
I hope not.
Oh my God, we're starting off early. Okay.
Where's Brooks?
Where's Brooks? He's not here yet. It's I think they're not getting there for another 9 minutes or so.
Okay. What did I miss yesterday? I assume they came back from lunch. He had a big fight with the judge. The judge threatened to send him to the bad boys room. They kissed and made up. A few foundational witnesses came in, then they went home.
Yeah, kind of nailed it. He almost got thrown out of the courtroom, which is, who cares? Like, you hold me in contempt, Your Honor. You hold me in contempt on the record. Is that a verified proof, Your Honor?
He has so many problems.
We still trying to get around that. No plaintiff, though.
And asking leading questions on cross-examination.
There's no, and get around that no plaintiff. Yeah, it was. It was kind of a disaster. But it's the same stuff. It's the same worthless arguments that he's making constantly. She's starting to just say, yes, it's a judicial determination, which is good. She should always do that. Like when she's making a ruling, yes, it's a judicial determination. Fuck off. I don't know why she's so resistant to it, in all honesty. It weirds me out.
Well, it's literally a determination made by a judicial figure. So why wouldn't you just say yes? If you don't like it, appeal.
Yeah, exactly. And because the thing is, he's not going to appeal. Like he hasn't figured out that he could have appealed several things by now. I mean, not successfully, but he could have delayed and appealed. Some of these orders are appealable, interlocutory appealable, and he's just not doing it. So if he's not going to do it, just say everything's an order. It all is. And just say, yeah, appeal it. She said that a couple times. It's like, say it for everything.
How close did he get come to being thrown out of the room though? After lunch.
Very close. Very close. I don't think it was directly after lunch. I want to say it was during one of the between some witnesses. But I mean, something happened. I can't even remember what it was specifically, but he was bitching about it. He had muttered under his breath too several times during redirect, I think. Like, and the judge said something. He said, "You trying to be slick like that?" And so between the witnesses, she said, "Okay, we're gonna have the jury step out for a minute." They stepped out for a good minute. and she made a record of his disruptions and he was being really, really disruptive, like actually disruptive. Stopping her constantly. And she says, "Mr. Brooks, if you interrupt me one more time, literally once more, I will send you to the other room. I will send you." It's like a mom. Like, "I will send you over to timeout." And he's like, "I won't interrupt you, Judge. I'm just saying." And she's like, "You're interrupting me right now." And so he finally shut his mouth and he allowed her to make the record. But then he's like, he's like, "Are you telling me to be quiet? Or are you asking me to be quiet? Because nobody tells me what to do. I'm a grown man with kids. Nobody tells me what to do." It's like, well, I mean, some people do. Like the bailiffs
and the judge. Yeah.
Yeah.
Well, see, this thing is it's funny, but it's not,
it's not funny enough is the problem for me. It's just not funny enough to keep me entertained through all of the nonsense. That's my problem.
I've just been thinking it's like the guy that tells the same joke at every party.
Yes. Oh, God.
You've heard it 10,000 times, and it was funny the first 3 times.
Yeah. Yes. I know that guy. I am that guy. Oh, man. He leaves right after I say it. He fucking leaves. Ah, damn it. Savvy Sue, I'm not sick. I'm just tired. This is just my morning voice. We'll get into it in just a minute. Oh, you got to do your morning stretches or whatever. I got to order a standing desk. No more of this sitting desk tyranny. We're going to be awake and alive. We're going to live life. Okay, who else am I inviting today? Let's see. I agree, not everything is sexual. You guys need Jesus. Wrong. Jesus is sexual as hell. Speaking of sexual, I'm gonna ask you guys to click my button out there in Rumbletown. I'm gonna ask you to go ahead and click that plus button. And if you're on mobile browser, click that boxing glove thumbs up. That way, what's up, Jeff? Welcome back.
Yeah, this is what's been happening to me all night. It just suddenly decides to shit the bed and do that sort of thing.
But yeah, hit that plus button on Rumble, hit the thumbs up on the mobile app. Let's push this thing up to the front page. Let's make sure everybody knows where they can watch the trial with like actual good coverage, not this law and cuck bullshit. And let's get people in here. And yes, ladies, I have sent Peter Tragos the link. So gird thine loins. You should have seen the damn locals chat. There were waterfall memes going off.
Oh, nice.
I was like, yeah, maybe I'll send Peter Tragos the link. And it's like, who's Peter Tragos? And then people start like sending pictures of him and stuff. And chat went into horny overdrive. It was like we went to we went. I don't even know how to word this without getting banned from Rumble with what happened there.
Oh dear. Yes, pray do tell.
I'm just saying, I needed a mop. That's it. It was bad. It was bad.
Can you just
Yeah, Andrea Burkhart. I could invite her.
It's the lawyer you fantasize about.
What?
The lawyer you fantasize about.
You're talking about Peter Tragos?
Yeah. Not one. Yeah.
Okay.
I'm not going to finish that sentence.
Well, it was right after I had said I could invite Andrea Burkhart. God, the court is fucking loud today. Hold on.
I still like Andrea, and I still want her to like me, so I'm not even going to joke about that.
each?
Andrea's
Give
awesome.
one to each party. Thank you.
All right, hold on. There we go. Next.
Wow, that didn't look like Chrome. What are you using to do this?
Well, I have Chrome running for some shit, and I have Edge running for the trial stream.
Huh.
I like when
Maybe Edge will
Microsoft
help
edges me.
No, you can.
I'll have to give Edge a try and see if that's better than my stupid Chrome bullshit that's going on.
You can. Sam, go ahead.
In case
I
you
was gonna call
didn't
him
hear,
Case.
and in case the chat didn't hear,
You need
I
something
actually
to
have
talk to him
end
for a second?
right
Go ahead.
around
Do you want you can
lunchtime
turn the audio
today.
off for a second?
Good, me
because
too.
I got to go. I have to go teach.
Oh, it's Thursday, isn't it?
Yeah, it's Thursday, and this trial's been going long enough that we had our week off, and then there was the next one. This is typically every other week.
All right, good morning, everyone. The court will call State of Wisconsin versus Darrell Brooks, case number 21.
That's the face of a woman who knows she's just about to get into an argument.
Just another Anon L says hot
Leslie
tube
Basie and
stream
Zach Witchow
when
appearing for the
to you.
state of Wisconsin.
Good morning, sir. Please state your name for the record.
Just one second. Make sure I have everything since Dave's coming late today. I'm here as a third-party intervener in that matter, appearing as authorized representative for my client.
What client?
I accept for value in return for value all of the charging instruments in this matter and make my exemption available for the discharge of all obligations and charges connected with this case. I do
On
not
paper.
dispute any of the facts in the charging instruments and do not consent to being called that name for the record.
All right, thank you. That is noted. The record will also reflect that the individual known to this court as Darrell Brooks is present in person in custody. He is wearing street clothes, specifically a suit and tie and a mask as well.
And don't consent to being called that name.
I understand, sir.
He's,
All right, I
don't
do want to
consent.
put on the record I gave the parties this morning. It's an excerpt from a judicial bench book on opening statements. It's about a page and a half.
Oh, did we get opening statements
I thought
right
it would
away
be
today?
helpful to provide to Mr. Brooks as he puts together his opening statement.
Her hair gets more and more frazzled as the week goes
Some
on.
Supreme Court rules, SCR, some case law, talks about the manner and purpose, scope, and other things. And as I indicated yesterday, sir,
Oh, this will be great. I can't wait for opening statements.
I like to call it the roadmap. It's referred to here as a framework so that the jury can better understand and evaluate evidence.
I hope he doesn't do them right after lunch today.
Based on the
I hope
law
he does them now.
and the evidence you believe is properly admissible.
I don't think they
I'm
rested.
going to further advise you at the time when you
frankly,
do
I don't
make
even
your
remember.
opening statement.
That good, was it?
Did not reference subject matter jurisdiction.
Speaking
That
of
is,
not remembering,
despite what I know
ladies
you
and
believe
gentlemen,
to be to the
if you're out
contrary,
on
it is
Rumble or
not
Odyssey land, where
a
you
requirement
should
to
be
be
is
proven
on
in this
locals.
case.
Rekieta Law.
It is not
locals.com.
factual or legal argument that is accurate, and therefore I'm prohibiting you from referencing that during either opening statements or closing arguments. With that, I believe
For the
there's-
record, is
For the
this
record?
is this the which you're referring to? This
the page and a half is from my judicial bench book. I thought it would be helpful to you so that you have a better awareness and understanding of the manner and purpose of an opening statement. This is what guides me as I preside over cases.
Okay, I accept for value and return for value these documents.
You don't return anything.
I don't know why the reference to subject matter jurisdiction in the opening statement. I'm pretty aware that wouldn't be part of an opening or closing statement.
Oh, yeah, sure. Right.
Okay, great.
I don't get why that.
As long as we agree.
I wanted to make the
relevant.
record. So I appreciate you indicating to me that you're aware of that.
Even though subject matter jurisdiction has not been proven on the
Blah,
record,
blah, blah.
and should
Sure,
be
it's a beautiful
it does
sound.
need to be proven on the
Yeah.
record. It's established by law and by the fact that, as my written decision indicates, commenced when the criminal complaint was filed in this case. It's conferred by Constitution and by statute.
And who was the complaint filed by? 'Cause
Jesus himself.
it has yet
I'm
to
not
be
going to go
proven
down
on the
this
record.
path today. I'm just advising you, you cannot reference that in your opening
I mean-
statement.
That was something I've already had the common sense to know, but also
Really?
fiction has not been proven for the record.
All right, next topic then. I believe the state has
Should be
filed
proven
a
for the record
motion.
by the prosecution.
The objection is
Alleged.
noted. It is not legally sound. It's overruled.
It's definitely legally sound.
Oh,
Right.
Has yet to be
Attorney,
proven.
I'm going to turn to Attorney Opper. I believe they filed a motion
The problem with him,
this morning.
God,
Has
who's
been pulled through. I probably just need to refresh, but.
their fucking microphone set up here?
It was served on.
the court is really hot today, and I'm not just talking about the judge.
Yeah, no.
All right, go
I
ahead.
didn't-
You can make. Let me just-
I didn't look at the document. I accept for value, return for value the document. I didn't look at it.
Look at the documents. That's why you have so many questions.
So I don't know what I'm supposed to say to that.
All right, well, Attorney Opper, it's your motion. I'll hear from you.
Your Honor, we are moving to amend the information with respect to one word in the entire document. We're asking to change the location of count 76. The information reads as it reads right now, it reads at Frame Park. We're asking to change that to near Frame Park. We believe that that's a more consistent statement that aligns with the testimony of victim PPP, Erica Patterson, as she testified in this trial. We're not asking to change any criminal charges. We're not asking to change any dates. It's, I think, a very small change in the charging document. The defendant has been on notice of the facts of this transaction. It's reflected in a number of police reports and Ms. Patterson's recorded statement, which the defendant has copies of. And so I don't think that there's any grounds for a claim of prejudice by this change, and we're asking to move forward with that amendment to the information.
Prosecutor McHottie needs a raise. I don't think he's worn a different suit through the entire trial.
No. Well, he removed his sweat
First of
glands.
all, for the record, there were originally 2 charges associated with this one party, and these charges have been charged for the better part of a year. I feel that if there was essentially one word that needed to be changed, it's been more than ample time for it to be changed. Even after one of the charges was dismissed, it could have been, that topic could have been visited at that time for it to change. I don't think changing one word at this point really has any bearing on the testimony or the actual charge. I don't understand why a motion needs to be heard about one word. Is I think kind of at this point kind of a moot point. It's been charged like this for a year basically. The language hasn't ever been referenced to being changed before yesterday.
He has no idea why
So
he's
what
objecting
is the
to this.
significance of this now
Yeah.
at this point?
Thank you, sir. Section 971.29 sub 2 of the Wisconsin statutes, which provides at the
Statutes.
trial, the court may allow amendment of the complaint,
I
indictment,
just
or
cannot imagine
information
that
to
accent in
conform
bed.
to the proof where such amendment is not prejudicial to
Yeah, go lower. That right,
Oh,
right there.
states
Go
that
ahead.
when an amendment to the charging
I hate
document
you.
does not change the crime
It's
charged,
worse.
and when the alleged offense is the same and the results from the same transaction, there is no prejudice to the defendant. State versus
The
Wickstrom.
Richards Darrell sex
118
tape.
Wisconsin 2nd, 339, found at page 348. It's a Court of Appeals case from 1984. And also, I point the parties to State versus Durango, 229 Wisconsin 2nd, 1, and State versus Gerard, 189 Wisconsin 2nd, 505. The first of those two cases is a Court of Appeals case from 1999. And then the second of those referenced is from the Supreme Court from 1995. I'd also point the parties to State versus Frey, 178 Wisconsin 2nd, 729, a Court of Appeals case from 1993.
It's almost as if she was ready for him to say that.
Whether this is a moot issue or not, I'll find that it is ripe for determination by this court to hear this motion, and that is because the jury ultimately
Gotta
will
get
be
that
instructed similarly to what the jurors were instructed at the beginning of the case. The charges are read. Those are based off of the information. And this proposed
Damn
amendment
it.
does conform to the proof.
Looks like
There
the
is no prejudice to Mr. Brooks. It does not
looks like
change
River by Ed Sheeran is
the
stuck
charge
in my head
in
now.
any
Thanks,
way.
chat.
I'm
It's
sorry.
still the same
I'm sorry to
offense.
hear that.
It's still from the same general information that was indicated in the criminal complaint. So for all of those reasons, I will grant the state's request to amend the information, and the state may file that document as soon as possible.
I have a question about that. So this same person is scheduled to testify again. What if something changes in the testimony?
I'm not going to answer that, sir. It would require me to speculate on what that situation might be and to give an advisory opinion, which
Then you pointed out to him. How about that?
What happens if that happens?
I'm not going to answer that, sir. I can't. You're asking me to give an advisory decision. I'm not going to do that. I'm not allowed to do that, actually. Okay, so we dealt with that
Makes
then.
no sense.
The state has not rested yet. Will the state anticipate calling any other
Please,
witnesses?
God, just rest.
No.
Yes, Your Honor, as
Oh,
indicated yesterday,
fuck
we
you,
do intend
State.
to recall Detective Casey.
Set this
to the
man free.
stand, and I'd like to make a record in
Just
that
because
regard,
they're going to
please.
keep going.
Your Honor, Detective Casey did testify once for the state early in the presentation of the matter. His focus at that point was largely on assisting the jury in understanding the layout of the parade route, giving background and contextual information to the jury, the different parade units that were impacted, what they looked like. We showed several videos with Detective Casey just for background and context purposes. He then went on to describe his personal interaction with the SUV as it came through the intersection of White Rock and Main. And essentially, that was the bulk of his testimony during his first testimony. We're seeking to recall him now. This is not unusual. It is commonly done in cases. We never excused him from his subpoena. We never asked for him to be excused from his subpoena. We always intended to recall him. We did this so that we can efficiently present the information to the jury. The types of questions we have for him now go more to the investigation itself and his role as the lead detective in this case. There will not be duplication or repetitive questions. I'm not going back to the corner of White Rock and Main with Detective Casey during this round of testimony. We want to ask him essentially about how some of the victims along the parade route were identified. We want to ask him about some of the topics that have been addressed throughout the course of the state's case, as far as identification of the vehicle and identification of the driver. And we need to still introduce the certified bail forms from Milwaukee County for the 2 bail jumping counts. So he will be asked about that. I estimate my direct examination of Detective Casey would be about 20 minutes. So this is not going to be repetitive. It's information, again, that he has as the lead detective in the case to assist the jury in understanding some of the things on the back end that he was involved in, not his role at the parade. So we have been very efficient in our presentation. I believe Your Honor would agree with that. We're not wasting time here, but we just have more questions to wrap this up.
All right. Any position from you, sir?
And yes, I do. And I'm gonna start with what was just said. The prosecution feels that they've been efficient
They've been in fishing.
in their presentation.
I disagree.
So it seems like to me an attempt to get more questions in that could have been asked in the first place. If Your Honor recalls, Detective Casey was testifying for quite some time, to the point that we actually had to have a break before I can cross-examine Detective Casey, if you recall. He was up there quite some time. That was more than enough time for any other foundations to be laid, any questions to be asked at that time.
It's not how this works.
And also, from
It's not how any of this works.
he was asked to be excused. So essentially having him start off and then end it, I feel like it's an attempt to get questions that was maybe forgotten to be asked, answered. And it's
Hashtag grasping at straws.
what more could be gained by a second testimony from Detective Casey? What more can be gained that hasn't already been learned? We learned about vehicles and identification by numerous witnesses. We've been through the inspection of the vehicle. We've been through DNA analysis of the vehicle. We've been through numerous things in regards to the vehicle. Even the reconstruction testimony. We've been through all of that. Seems like nothing more than to get extra questions answered that could have been asked from the get-go. As seeing as how he was up there for quite some time and none of those issues were raised at that time. What would be the significance at this point? When it's essentially, I should be already presenting my defense at this point in trial. I don't see the relevancy of it, and to my knowledge, he was excused from his subpoena. So,
Thank you,
the
sir.
relevancy?
Thank you, sir. The court has discretion under 90611. It's a statute I've quoted with frequency during the course of these proceedings. I've listened to the state's offer of proof. I've listened to the objections made by the defendant.
I hope he wins this.
In my discretion,
I was just thinking that.
Detective Casey to be recalled for the reasons laid out by the state.
Damn it.
As I understand his proposed testimony today, it is not to rehash topics that he was questioned about initially.
And this is going to trigger a 30-minute fight.
And
Yeah.
role subsequent to the initial contact. with Mr. Brooks at the beginning of the parade route. And as the state indicated, we'll address certain things, including identification related to the vehicle of the driver throughout the investigation,
I'm
identification
so
of
goddamn
certain
mad right now.
victims. In addition, there are
The
two
OnlyFans
additional
murder
charges for
trial
which
is
the
going, and
state
I'm
has
stuck
not
with
yet
this
presented
banger.
testimony.
Fuck
So
this
it's proper
guy.
for
God
those as
damn
well.
it.
It's relevant, and I will allow it for those reasons. So the state will be able to recall Detective Casey, and we'll have that done, obviously, when the jury is brought out. Any other preliminary issues then from the state?
No.
Your Honor, just, I am working on going through our list of exhibits, and I will work with your clerk to make sure that everything that I'm showing was admitted and accepted.
Well, nice to see her cold is cleared up.
She has, so that we can clear that up before we actually rest.
All right, thank you.
Her bubonic plague has ended.
Anything preliminary from you, sir?
Yeah, just a quick question about the last.
God damn it, I'm so mad. I would so much
I
rather
will
watch
be
that
able to
fucking
recross-examine it.
OnlyFans chick
Oh, yes, you will.
on trial than this
And-
fucking idiot.
Which OnlyFans chick?
Essentially, anything
The
left
one who
off
stabbed
limits
her
to my
boyfriend to
cross-
death
With
in the neck.
That's not going on right now, is it?
That's what I'm hearing.
They just had some new. They just released some body cam footage yesterday.
May limit, depending on where we go. If
Maybe it's just pre-trial shit.
questions deal with what he
I would
testified to previously.
that trial would be great to watch.
Yeah.
Primarily to cross-examine.
Yeah, they released the 911 footage.
However,
The 911 recording of her saying, "Oh, I'm so sorry. Oh, I'm so sorry. Please help me. Oh, I'm so sorry, honey."
any
Doesn't
issue,
look good.
Including credibility, does say in the interest of justice, the judge may limit cross-examination with respect to matters not testified to on direct. So I'll give you some leeway. And I'll trust the state will make appropriate objections, and I'll rule on them if and when they're made.
because I'm not intending to go too much back into the previous testimony, but I think it made a few points from the earlier testimony
I
may
think that's
come into
fair.
play, and I just wanted to make sure.
Okay,
I
it
think
sounds
that's
like the
fair.
trial
That wouldn't
itself
be a
is
problem.
not on yet. Just like you said, just
think that's fair, sir.
some pre-trial shit.
Also, really quick, I did look over some information provided by the prosecution as far as the pretrial offer that I did not have knowledge of until, I don't know if that was today, Thursday. I don't know if that was Monday or Friday or Monday, one of those days. I'll put together, started to, I won't say it's completed. That wouldn't be fair to say. I've put together, or started to put together a counter offer. So I just wanted to advise the court that I was putting that together.
All right, thank you, sir. When,
You may want to talk settlement before this point in the trial.
so we can make a record of that. All right, anything else?
Oh dear.
No, then we'll have the jury brought out.
We do have one last large map here, Your Honor, I'm going to ask to put up and face backwards like we did the other day.
All right, go ahead, since the jury's not here.
Okay.
In the meantime, have you tried Rabbit Hill Cave Hill bourbon?
No, I've had
Rabbit Hole. Yeah.
I've had Rabbit Hole.
Yeah.
Not
this
that
is-
one.
Yeah, it's the Cave Hill Straight 47.5. Pretty good.
I liked the other one I had. Which the hell? Be right back. Not like I'm doing anything else.
Thank you.
Officer Tackleberry remains unamused. This guy has had that same exact expression since the first time he was in court.
I can't find. I think I've had a bourbon, but I found this one, the rye.
Oh,
The
you're into ryes
Kentucky
these
straight
days, aren't you?
rye. Dude, I like them.
all rise.
But that was, I mean, I probably had that a year and a half ago. What are y'all eating for brekkie? Breakfast?
Whiskey.
What, am I fat? Nah, breakfast is something I don't usually eat. I like breakfast, but I'm not. First of all, I'm not usually awake until the middle of the day, and I'm usually waking up when I need to do something immediately. And so then I just get immediately wrapped up in doing some
Thank you,
sort
everyone.
of
Please be
work
seated,
or
and
task.
good morning, ladies and gentlemen of the jury. I know it's a little chilly in here. I'm not sure if that will change.
How
now
can
that
you
we're
tell,
all in
Judge?
here. If every time that temperature is too cold for you, let me know and we can have that adjusted.
Turn that AC down low.
All right, Attorney Opper, you may call your next witness.
Thank you, Your Honor. The state would recall Detective Tom Casey.
Good morning, Detective Casey. Please make your way to the witness stand. When you get there, please remain standing. Raise your right hand, and Teresa will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, sir. Please have a seat. Please state your first and last names for the record.
Thomas Casey.
Thank you. Go ahead, Attorney Opper.
Thank you. Detective
Make it quick,
Casey,
state.
I'd
What the
like to
hell could you
begin by
possibly need
asking
this guy
you
for?
to refer to the item behind you. There's a large poster board there. If you could please place that on the easel and identify the exhibit number for the court.
It's exhibit number 15.
Thank you.
That is a fly-ass visual aid. Like, that's
And
a
we
really
had
good one that they
testimony
made.
about this exhibit throughout the trial,
Yeah.
right, sir?
Yes, we have.
All right. Your role in this case was what, sir?
Objection leading.
Overruled.
Initially, I was on traffic control for the parade. Shortly after the incident happened, I was assigned as lead detective for the case.
Were you the individual who created this map, State's Exhibit number 15?
Yes, I did.
Okay. And I would like you to talk a little bit about how victims were identified in this case.
Objection leading.
Overruled. Foundational. The witness may
It's
answer.
also just not leading.
So at least
There is that.
can you tell us, like, in the day or two after the parade, what happened?
Objection leading.
Overruled. You may answer.
So initially, that night, we knew that the victims were taken to different hospitals around the area, generally 5 different hospitals. So at the beginning, we began by having detectives assigned to each hospital. Waukesha Memorial Hospital received the most patients, so they also had a lieutenant that was assigned there as a team leader. As the patients came in, they were identified by detectives. The hospitals also provided us with lists of patients that they had, and we went through those lists and tried to identify people that came in and were being treated.
And then eventually were there follow-up interviews conducted with these individuals?
Yes, there were.
What if the individual was a person under the age of 18?
Objection leading.
Overruled. You may answer.
If the person was a minor under 18, then we would reach out to their parents, talk to the parents. Some of the kids weren't able to talk to us, but we got the majority of their statement from their parents.
Okay. And do you believe that the names on Exhibit 15 truly reflect all the injured victims that you were able to identify in the course of this investigation, sir?
Objection speculative.
No, I do not.
Hold on. There's been an objection. It's overruled. And the witness will repeat his answer.
No, I do not.
Can you explain that?
Objection leading.
Overruled.
Just because of the scope of the investigation, we had so many people that were hurt. We had to come up with some kind of parameters to limit the people that we would call victims. One of those parameters is that they had to receive treatment at a hospital. Another one is that they had to be in the street when their injuries occurred. So there are some people that were injured, maybe on the sidewalk, trampled by the crowd, or received injuries that they didn't get hospital care from. You know, and unfortunately, I learned later on there was even a person that was in the band that somehow we missed her being reported that she received a broken leg. So there are some that are not on the map, but all the people that have been charged are on the map.
So you mentioned people on the sidewalk. We did have some spectators testify in the trial, correct?
Objection leading.
Overruled foundational.
Correct, but they were more in the roadway or on the curb, not on the sidewalk or not running away
Guys,
from the incident when it happened.
I gotta confess, I am in the courtroom
So-
today, but I have a
Was
wig on
In
and
your
I
mind,
shaved.
when you were leading this investigation, trying to identify victims, what was the importance of the SUV in the injuries that were caused?
Objection leading.
Sustained as to the form of the question. Please rephrase.
Why were the spectators that are on this map included?
Because they were directly contacted by the SUV that came down the street.
If a person were injured because they were trampled by the crowd, are they on this map?
We
Objection
exclude those,
speculative.
Overruled. The detective may answer.
those people were excluded from the map.
There were some people like that, right?
Yes, there
Objection
were.
leading.
Please make
Sorry.
sure. Thank you. I'll allow his answer to stand. Next question.
All right. I'd like to put up for you exhibit number 32, which has been previously identified. I'm sorry, admitted.
I'm sorry, you said 32? You said 32? Okay, thank you. Sorry, I just missed it. Just to the witness or published because it's been received.
Yes, we are going to publish this, Your Honor.
Go ahead.
But
Permission granted.
Legal voices.
And while we're waiting for it
At
to
the
come up in
next
the
break,
jury
fat
box,
shame you to your face.
I don't have
Okay,
it on my screen.
I will.
It's on.
Second, hold on.
If I can
Got to
fit
do
it all
something
in
for
the-
entertainment.
Not-
If I can fit it all on the
Let's check cables.
screen.
We'll see.
We don't have it
Yeah.
either.
I can see it. The witness can see it.
Mhm.
Go out it. Thank you for letting us know, sir.
It's just the front tables, back tables on, Your Honor.
I can't unsee this court reporter now. It's freaking me out.
Yeah, thanks, Odyssey chat, you fuckers, for pointing that out to me.
I know.
Chat's saying I should slut shame you
Yeah.
instead.
You can see it on the screen though, right?
Nah,
sir?
that's weak.
Maybe for those pineapples.
There's screen, you can see on the far side of the courtroom and then to your right.
It's
Ooh,
always better
there's a,
on
there we
your
go.
side.
I understand. We'll get our tech guy over here to look at it, but it's previously been received and we can see it on the two.
Chat's trying to help
other
me get a different
monitors.
song in my head.
So for now, we're going to continue. If there's anything new,
Sex
I'll
and
make sure to
Candy by
pause.
Marcy Playground. It's been a long time,
ahead.
man.
Baby shark.
Detective Casey, I want to
Baby
focus your
shark.
attention specifically as to the extreme dance team. We heard testimony about several of the girls on the team being struck and injured. Do you remember that testimony, sir?
Yes, I
Objection
do.
leading.
Overruled, it's foundational. The answer may stand.
Do you know if there were other people associated with the extreme dance team that were injured?
Objection speculative.
Overruled, he may answer.
Yes, I do.
And do you know the names of these people?
Objection hearsay.
Overruled, he may answer.
Yes, I do.
What were their names, please?
Kathleen Pellmeyer,
Speculation.
Overruled, he may answer.
Go ahead, sir.
Kathleen Pellmeyer, Jennifer Stover, and Mitchell Lampine.
What was their role with the dance team?
Go ahead.
Jennifer and Kathleen were support people. Jennifer's daughter was marching the parade. And then Mitchell was there to hand out candy with his stepmom.
Okay. I'm going to now play, it's still not being displayed on our tables, Your Honor, but it is displayed on the two large monitors in the courtroom. So do I have permission to proceed?
Which exhibit?
This is 32.
Oh, yes. If we get to a new one that hasn't previously been received, then I
Yes,
will
okay.
pause to get the
Alright.
tech people in.
All right. And
Go ahead.
Objection
Bailiff.
as to relevancy.
Overruled.
The bailiff.
Probably vodka in every one of those water bottles to help the witnesses.
All right, please play. from the 32-second mark, I'm sorry, 35-second mark. to
35-second
47
mark.
seconds.
How long is the exhibit?
Objection relevant.
Looks like it's a minute 23 according to what I can see on my monitor.
It is 123 total. We're only playing this 12-second clip from 35 to 47.
Thank you.
And please pause. Do you see any of the individuals you were just testifying about enter the screen, sir?
Objection speculative.
Overruled. He may answer.
Yes, I do.
Could you identify them by using the touch screen?
Objection leading.
Overruled. He may answer.
I'm going to draw one big circle.
Okay,
It has two individuals, it has Jennifer and Kathleen. Kathleen has the red jacket on, and directly to her left would be Jennifer in the black jacket.
okay. A little hard to see right now, but as they,
Very hard to see.
as they
Keep going.
walk, could you see two people walking there, sir?
Yes, ma'am.
Okay. Please clear the screen.
Sorry, I'm distracted. I'm dying.
I'll take things I can never unsee for 400, please,
Sorry.
Nick.
See the counter, Your Honor.
It is at 44 seconds.
So everybody else in
Thank
the
you.
locals
Pause
chat
at
yesterday,
44. Do you see anybody else that you
people
just
were posting
testified
sexy
to
pumpkin
in the,
pictures.
in the video at this point, sir?
And then one of the
Overruled. He may
locals
answer.
members' dads
Yes, I do.
saw
And who
them
is that?
Leading.
and sent a horny post.
Overruled.
Thought
Mitchell
to his
Lampine.
thought to her mom,
Please
but
circle
sent it to
Mitchell.
her instead. Oh shit!
Do you know Mitchell's approximate age?
Objection speculative.
Overruled.
Oh god!
I believe he's about 10.
Okay. All right, we can take down 32. Did this video goes on to show the red SUV drive through the extreme dance team, correct?
Objection leading.
It's foundational. Your Honor.
Overruled. It's foundational. It's previously been received. Go ahead.
Yes, it does.
To your knowledge of this video, sir, did those individuals, Mitchell and Ms. Stover and Ms. Pellmeyer, remain along the left side of the road there as the SUV went through?
Objection leading.
Overruled. The witness may answer.
They were hit by the vehicle and then moved to the left.
Let's take a pause for a second. We
Yes.
have our IT experts. Hopefully I can get this figured out.
A lot of pressure.
Go ahead.
IT experts, what's wrong?
Something on the screen that's okay to view for the moment.
You've been doing
Next
this
one
for
will be
weeks.
132.
How is it broken now?
It's on our screen.
It's on now.
Hold
got
on,
it.
let's make sure. Do you have it now, sir? Yes?
Yes.
Oh, good, great. It's on mine, it's on the witness. All right.
Just
Thank
like
you.
real life. You call the help desk and they show up and now it works. Yeah.
Clearly,
Oh,
the
yeah.
IT department isn't giving value
Your
for
numbers
value.
were working. It's not, hold on, let's make sure. It was just working. There's a
Try it
delay.
on Lady R. I need the source picture.
It can take 30 seconds.
Someone send me the source picture. We can do it.
What exhibit is this one?
This is 55.
All right, it's not. Very good. We're up and working. And 55's previously been received, so go ahead.
All right.
Objection to the relevancy of 55.
Noted, overruled. Go ahead, Attorney Alper.
Detective Casey, Exhibit 55. Can you see at the end of the road there or the top of the screen what unit is involved in Exhibit 55, please?
Yes.
Please tell us.
Objection leading.
Overruled.
It is the dancing grannies that are approaching from the right.
Okay. And one of the dancers, we have her testimony that was involved with the grannies was a woman by the name of Lola Hospital. Is that correct?
Objection leading.
Overruled. It's foundational. The witness may answer.
Yes, she was.
Is there video showing Miss Hospital being struck by the SUV?
Objection leading.
Sustained as to the form of the question. Please rephrase.
Sure. Is the exhibit, you've seen exhibit 55 before?
Yes, I have.
Are you able to identify Miss Hospital, yes, Lola Hospital in exhibit 55, sir?
Objection leading.
Overruled.
Yes, I am.
All right. We're going to play the clip, Your Honor, from from 4 seconds to 8 seconds at 50% speed. And it is zoomed in on the middle of the road where the dancing grannies are located.
I think she's
All right,
still
go ahead.
asleep,
Thank
so
you.
she's going to wake up to this message. There you go. If you wear this, I'll go trick-or-treating with you.
Please describe for the jury what you just saw in the video, sir.
Objection leading.
Overruled.
I'll just wait
I
for her to
saw
wake up.
the red SUV driving westbound on Main Street, approaching the dancing grannies and hitting Lola Hospital and then striking 2 other dancing grannies.
When you say hitting Lola Hospital, what did you see?
Objection leading.
Overruled. You may answer.
I saw the left side of the car come in contact with her, and then her body moved to her left after.
Did Miss Hospital report any injuries to the Waukesha Police
Miss
Department?
Hostel.
Objection leading.
Hard to talk
Overruled. The
to.
witness may answer.
Yes, she did.
All right, sir. I'd like to now ask that Exhibit 118 be published for the jury. This has previously been admitted.
Permission granted.
Objection to the relevancy of 118.
It's previously been received.
Make trick or treating great again.
Sir, do you recognize the item shown in Exhibit 118?
Yes, I do.
And in addition to the photograph, have you had an opportunity to examine that item or items
Objection leading.
personally?
It's not leading.
Overruled. The witness may answer.
Yes, I have.
And Mr. Johnson from the crime lab testified about these items yesterday, but I'd like you to tell the jury what you remember of these items, please.
Objection leading. Informative. The first part of the question.
Read the room, bro. Do not be making these
Overruled. The
stupid
witness
objections
statement.
when they're showing a picture of a crumpled hood and an old lady's costume wedged
So
into the hood.
the red
Jesus.
SUV that was used in the parade attack, this is a picture of it taken after. I remember a hood from a white jacket and a hat, a black hat with snowflakes on it, being pressed in between the hood and the windshield wiper of the vehicle.
Objection to it being called an attack. I think that's a disparaging remark.
Yeah, that's a good
for the
objection.
record.
Actually,
Your
That's-
objection is noted.
no, sustain
And
that.
the answer will stand.
No.
I actually
I
disagree
will
with that.
instruct the witness to simply describe what he,
Oh,
Look
look
at
at that
his smug
smug ass
look.
smirk.
further characterizing it.
Gotcha,
The
bitch.
jury to determine the facts in this case. Go ahead.
Thank you.
That was actually, he
You
was
saw
right
these
on that
items on
objection.
the
He was right on
Hood
that one.
of the red
Yeah.
SUV.
It's a very prejudicial
Did you
statement.
later
It should not
come
be
to,
made in that way. There's no reason
recognize
to.
where they may have come from.
Objection leading.
Overruled. The witness may answer.
Yes, I did.
What did you determine?
I determined that
God,
they were
that
the
smirk was just something
jacket hood and
special.
hat that Virginia Sorensen was wearing while she was walking in the parade.
It's like Dilbert won a
To display
$500
to the
scratch
witness
off.
only, please, Exhibit 177. This has not yet been received, Your Honor.
All right. Go ahead, please.
Is
Was it a
177
good
on your
enough
screen,
curative
sir?
statement
Yes, it
after?
is.
No.
And
I mean, it does. It's not.
what do you
It's not
see
gonna
in
win the
Exhibit
case from it.
177?
Just don't do it. There's no
Objection.
reason to.
Overruled.
I see two dancing grannies carrying a Milwaukee dancing granny sign, and the woman on the left is Virginia Sorensen, and she's wearing a black hat with snowflakes, wearing a white jacket with a hood on it.
Move to admit 177 and permission to publish, Your Honor.
Objection to relevancy.
The objection is overruled. Exhibit 177 is received. Permission to publish is granted.
Said 177.
177, yes. Go ahead. And if the jurors would let me know when it's in the jury box as well, please. All right, thank you. It's there.
And again, just so we're clear on the record, please circle Virginia Sorensen in the hat in this picture.
Objection leading.
Overruled.
Not leading.
That is Virginia, and then this would be the hat and hood that
Meet Virginia.
I believe was found on the SUV.
Detective Casey, there were many videos that have been shown to this jury, correct?
Objection leading.
Oh shit! Team
Foundational,
Ruby
Your
says
Honor?
first shot on me.
Overruled. The
For the
witness
love
may
of
answer.
Mike, this is painful.
Yes, there has been.
Damn! Thank you for that. Very large.
To your knowledge, are
rumble
there
rant.
any videos that display the license plate of the red SUV as it goes along the parade route?
Objection leading.
Overruled.
Yes, there are.
Is it possible to
I
capture
guess I have to do
a
a shot. I
screenshot
can't do
from
too
those
many of these
videos
though.
to see the license plate of the red SUV along the parade route?
Going with Yellow Rose Premium Collection.
Which one?
Yellow Rose
I'd like
Premium
to
Collection.
display for
Ooh.
witness only.
Number 2.
Exhibit 150.
Cabernet
Go ahead.
Sauvignon finish.
Oh, that sounds good. They just have the 3 base ones here in Korea. They don't
Is
have the
150
This
premium.
one, I think you have to get this
Not
one
yet.
at the distillery. Someone got it for me.
It is now.
Sent it.
All right.
The 3 base ones are actually really, really good just by
Exhibit
themselves.
150.
Yes, I do.
Please describe what you see in Exhibit 150.
Objection leading.
Overruled.
Cheers, brother.
Cheers.
I see the red SUV that was driven through the parade route, and it's at
To
the
the day I
time
get to
when
come to
it was contacting
Dude,
the
you got to.
band members. In that photo, you can read the license plate number.
Do you believe this photo is a true and accurate representation of the events of the day?
Yeah, me drinking before
Yes, I do.
teaching is just me trying to
Move
bring the
admit
public school
150
experience to
and permission to
homeschoolers.
publish.
Leave me alone.
Objection.
As the brother of a 2nd grade teacher, I can confirm that.
Overruled.
Why does
Exhibit
Mr.
150
Vices
is
smell like
received.
corn?
Permission to publish is granted.
Shut up
That
and
would
take
be-
your medicine.
That would be bourbon.
The brownest of brown liquors.
The image is a little blurry, correct?
No,
Okay.
objection.
Can you please point out the license plates in the photo and read it for the jury?
ADP 9256.
Okay, if I circle it,
Yes.
Overruled. You may do so.
Looks like a 0256 to me.
that is the license plate number, and I read ADP 9256.
All right. Now I'd like to
We
show.
could always check the Google Earth picture in front of your house to make sure that's the right one.
It's right fucking there. I love it.
Please describe 151. Oh, please clear the screen, Madam Clerk.
This photo is of the red SUV on the parade route. It's just photo taken just prior to the Barrett's Logistics float. And the band director is in the lower left-hand side of the video. It shows the red SUV with the license plate number displayed.
Do you believe this photo represents a true and accurate depiction of the events of the day?
Yes, I do.
Move to admit 151 and permission to publish, Your Honor.
Objection to relevancy.
Exhibit 151 is received, permission to publish granted. The objections noted and overruled.
I recall this station, we had 140 exhibits. How did we get?
140 colons? What was that?
Keep going to the honor.
Detective, please describe what you see in 151. I think you did describe it. Strike that. Please circle the license plate and read it for the jury.
Objection leading.
Overruled.
ADP
You know
9256.
how hard it is to sit in front of a microphone when you have songs in your head? I don't know if the chat
Still not.
realizes
Okay, I'm
it.
sorry. Gotta wait for them.
I think they do. You're just dancing to your own soundtrack.
Not even lying.
Are we still on Ed Sheeran?
Go ahead.
Nope. Moved on for
Detective
now.
Casey,
What are we on now?
during your investigation, did you
Uh,
uncover any other
Marshmallow,
videos
one thing
linking
right.
Mr. Brooks to this same vehicle with this same license plate?
Dude, I don't make the playlist.
The
playlist makes me.
Overruled as to both counts. You may answer.
Yes, we have.
Could you describe this video for us, please?
Objection leading.
Overruled.
There's a video that we obtained from social media that shows Mr. Brooks standing next to the SUV, and you can clearly see the license plate.
Play the
number on
fucking
vehicle.
music video. Just play the
The
music video. Just
Video
do
was
it.
taken sometime prior to November 21st, 2021.
Okay, I'd like to display for the witness only Exhibit 175, please.
Was the car in one of his videos?
Oh yeah. Yeah.
Oh,
It
cool.
was hilarious.
Please
I
You
haven't
haven't seen
actually
that?
watched any. I haven't watched any of the videos yet.
Maybe we'll pull it up.
This is
Relevancy.
And interrupt the riveting
Ooh.
testimony.
No, like on a break.
You may answer.
Oh, okay.
Watched it the other day.
this is
It's
a
good.
photo. There's
Math
two
Boy Fly
individuals
can-
in the photo.
You drop bars.
The individual on the left, I know to be the person referred to as Darrell Brooks. It displays a vehicle, a red Ford, and it has the license plate number, which is displayed in the photo.
What is the source of this photo?
Objection leading.
Overruled. The witness may answer.
We obtained it through social media.
Okay. I mean, this is a photo versus a video.
This is the photo taken from
Hold
the
on.
video.
I understand the objection. It's sustained. It's foundational. This particular question, the witness may answer. Go ahead.
This is a
Overruled or sustain?
Overruled.
You said sustain.
What did I say?
Yes, you did.
Sorry.
I don't think she said substained.
Overruled. The witness may answer. Sorry. I'm taking notes. I was writing the word source, and I think that's why I did that. In any event, go ahead and answer. Sorry about that for any confusion I may have caused.
This is a screenshot taken from a video.
Move to admit 175 and permission to publish, Your Honor.
Objection to that. What's the relevancy? I don't see the relation.
Your objection is noted. It is overruled, and Exhibit 175 is received. Permission to publish is granted.
Sorry.
The jury would also let me know when it's in the jury box monitors or on the jury box monitors.
Jack Riley,
right,
Mr.
go
Peter
ahead.
Tragos is on the way.
Detective
In a little
Casey
bit, he
is,
said.
Person you know is Darrell Brooks in this photograph?
Objection. I'm consent to being called their name. And
Yeah, this is from that music video.
Overruled.
Fucking
The witness may
great.
answer.
I'm watching it now.
Please circle or X or mark in some fashion.
He's rocking the Crips and the Crip gear.
How do you know that's Darrell Brooks there? His back is to us.
objection leading.
Overruled.
I've watched the video in its entirety and I've seen his face.
Play the whole thing.
Video.
Object on the grounds of the rule of completeness. They need to play the whole
Absolutely.
thing. Please
We need the
do
best evidence rule.
Okay, that can go down, please. Detective Casey, in total, how many videos do you think were collected by the Waukesha Police Department during this investigation?
Objection, speculative.
Overruled. You may answer.
We have at least 65 to 75 files. Some of those files contain multiple videos, photos, could be 10 each. So I would say probably 300 to 400 videos we have collected.
What were the source of those videos?
Some of the videos came from different people that were at the parade. Some of them are from city-owned cameras, and some of them are from fixed surveillance systems from businesses that were in downtown Waukesha.
Were all of the videos that were available shown to this jury?
No, they were not.
Objection. Rudy.
Overruled. You may answer.
No, they were not.
Have you personally observed
Well, this
and
isn't the whole video.
reviewed each
It's only
of the
part of it.
video files available in this case, sir?
There's a full video somewhere.
Overruled. You may answer.
Yes, I have.
To your knowledge, sir, did any video ever show a different person behind the driver's wheel of that red SUV?
Objection, leading.
Overruled. The witness may answer.
I have never seen anyone driving the vehicle besides the defendant in any of the videos that I looked at.
In any of the videos, were you ever able to see multiple people inside the vehicle?
Objection, speculative.
Sure, I could share the
Overruled.
video at the
The
same
witness
time as
may
the trial
answer.
stream, but it would the
None of the
sound would
videos that we have
overpower
looked
the
at
court. I
show
don't want
anyone else in
with
the
those
vehicle.
powerful lyrics.
Something
Any
about
of the
kidnapping
videos
something
that
on the way.
anyone show the red SUV coming to a stop, a complete stop along the parade route?
Objection, leading is
Oh.
speculative.
Overruled. The witness may answer.
I've never seen a video that shows the vehicle slowing or stopping while it was on the parade route.
Do any of the videos show the driver of the vehicle exit the vehicle to check on a person who had just been struck by the vehicle?
Objection, leading.
Overruled. The witness may answer.
I never observed in the videos the driver of the vehicle to stop and check or exit the vehicle on anyone.
There was testimony earlier in this case about witnesses observing multiple people running from
I
the
love
car.
his side
Do you
eyes
remember
that he
that?
does.
Overruled. The witness may
I
answer.
read an article about how
Yes, I remember that.
black emoting, like on social
Were
media,
there
is very
multiple reports
racist.
like that, sir?
But they're so fucking funny.
Initially, there were some reports like that.
When
black
the
people are just
vehicle
funnier.
was found on Maple Street, you weren't there.
Correct.
Objection, leading.
Ain't nobody got time for that.
Overruled. His answer may stand.
Like when he's sitting there, like
Do
on
you
the
know
record.
what police
On the
activity
record.
occurred
Look
when
at
the
look at his face.
Maple
Yeah.
vehicle was found on Maple?
What you talking about, Willis?
Speculative. Just stated he wasn't there.
Overruled. The witness may answer. He was asked, what does he know?
Nothing.
Yes, I do.
Please tell the jury what happened when the SUV was found on Maple.
Objection, leading.
Overruled. The witness may answer.
Initially, Officer Moss went, he secured the vehicle, did not find anybody in the vehicle. There was an initial report that saw some other people running from the area of the vehicle. After that information was given back to us, we sent detectives down to the area to investigate further to see if we could corroborate and find out if that was true or not.
After that investigation, did you have other suspects or just one person?
Objection, leading.
He's only 50% as
Overruled.
funny
The
with the
witness may
mask on,
answer.
though.
Based on the information of
Objection has been more than 20
on the
minutes.
route, and then the detectives that went back down to Maple Avenue where it interviewed the people that reported the people running. Our investigation determined that there was only one person in the vehicle and there was no other suspects that we were looking for.
Oh,
At some
what's
point
up,
in your investigation, Detective Casey, were
the
you
lawyer
given
you know, Peter? How's it
a
going, buddy?
Ford?
What's up, man? What's
Oh,
up, Legal
not much.
Vices?
Overruled. The witness may answer.
We're just
Yes, I was.
we're just here watching this disaster.
What was your understanding as
I
to
heard they
the
played a
source of
music
that?
video.
No, they just played a frame from it. We're gonna play it on
Oh.
the break, maybe.
Oh, I'm getting all
I
these
understand
DMs
that,
like
that
"Johnny,
he was
this music
taken
video.
from Mr. Brooks when he was taken into custody.
I got you
turned over
really
to
low.
Detective
Let me
Stern and Detective
fix
Kirk.
that.
Objection, I don't consent to being called that name for the record.
Noted.
So
Overruled.
this is
name was-
Rumble, huh?
How
This
did you
is
get
Rumble.
Feels the same. Feels just like old times.
You just stated.
Feels the same, except we got 14,000 people
May answer.
watching.
Nice.
Detective Stern brought me the key. The morning.
I can't hear him at all.
The incident.
You can't hear Peter?
I can't.
it? Did you do anything with the key?
Get out, Jeff.
Yes, I did.
Tell the jury what you did, please.
Objection leading.
Overruled.
It could be me. I've never done this Rumble before.
No, you're fine. You're coming through.
At that point, the
Jeff's been
vehicle
having
was at the
equipment issues.
Waukesha County Sheriff's Department secure storage facility. Mr. Johnson was over there processing the vehicle. I went there and I took the key with me and I checked the vehicle to see if the key would work in the car.
What did you
By
find?
the way, I've decided I need you to come to my
Overruled.
house, step on my shoulders, and pull my hair out so
I
it's as
found
long
that
as
the
yours.
key worked the door locks.
That's what I did.
on the
Yeah.
car. I also put the key in the ignition and it turned the ignition lock.
There's an echo. Just a second. Let me try this. Let me kick you out for a second. Hopefully this fixes the echo. StreamYard's been weird with
Detective Casey,
echoes
you've
lately.
heard
I actually can hear
testimony
myself
about the
in my headphones as
manner in
well,
which
like as an echo.
the defendant was identified by the name of Darrell Brooks. Do you recall that testimony, sir?
Even still?
Objection, I don't consent.
Yeah. I'll leave. I'll try leaving and coming back.
Yeah, come right back.
Overruled. Foundational. The witness may answer.
Yes, I do.
Did you endeavor to verify the identification of the subject you had arrested for this incident?
Objection leading.
Overruled.
Yes, I have.
Did you verify his identity by the name of Darrell Brooks?
Objection, I don't consent to being called that name. Leading.
Overruled. The
Okay,
witness may
hopefully
answer.
this is better.
Yes,
Yeah,
I
we'll
have.
see.
How did you do that?
I don't hear myself anymore, so that usually is a good sign.
Yes, yes.
There were a couple
Dude, it's been
different
too
ways.
long.
It's been
One
forever,
way
it feels
when
like.
the person is taken into custody.
We gotta do like a
we take
regular
the
show
fingerprints,
together sometime.
We check that against other records
Yeah, man.
that are kept by the state.
Did you guys
Those
talk about how
fingerprints
miserably unfair it
match
is that the state can just
Darrell
change the
Brooks.
information whenever they want
I've
in the middle
also
of trial?
spoken to
Wait, what?
three
do you-
women that he has
Oh, yeah.
children with.
From this
They
morning?
verified
Yeah.
that.
It's like, listen, we all want the state to win this case. I
Online.
get that, but it's so
I
annoying
also
that they can just
spoken to
change
his
the words
mother,
in an
which
information.
states that that's the name
What?
that
I
he
wasn't
is
even paying
gone by
attention when it
always.
happened. What was he bitching? Like, what was the issue? They changed a charge?
No, they just literally changed a
Put
word
on the screen
instead
for
of
the witness
at
only exhibit
the park
88.
to near the park,
Oh,
which to me,
Go ahead.
there's a difference there, right?
yeah, that's
Something
very
Exhibit
different.
88, sir.
But
Yes.
yet the state is literally allowed to do this, and that's just not against a pro se defendant. They do it against criminal defense lawyers all the time, and we are like, "What? that
Go ahead.
changes the case.
Overruled.
And the judge has
Okay.
to allow it as long as it doesn't prejudice the defendant. It's like, why would they do it if it wasn't prejudicial to the defendant? Why don't they just leave it then?
Yeah.
It's crazy.
To the counts alleged in this case.
Hey.
But hopefully,
Go ahead.
Hell,
Can you
well,
please
there.
identify exhibit
I'm back.
88, sir?
Oh, now I'm a bottom.
This is a bail bond through
I
Milwaukee
mean,
County.
when you know, you know.
For Darrell Edward Brooks.
Hey, then, Peter, we had our email exchange the other day. We were both delayed in our replies. Sorry about that.
Yes, sir. Don't worry about it. I
The
feel like
knowledge,
everybody is
was
overly
Mr.
apologetic
Brooks
when it
on
comes to this. 'Cause
bail
it's like,
through
I didn't mean to
Milwaukee
offend you. I
County
swear. I
on the
swear.
date of November 21, 2021.
Objection leading.
But I'm glad to meet you.
We're here.
For
Nice to
good
meet you
things.
too.
Answer.
Yes, he was.
And what is the date of this bail form? Please believe it's near the bottom.
The date on the bottom
Objection
is
leading.
Overruled. The witness may answer.
2/21 of 2021.
Was Mr., we'll strike that. By classification, can you tell us the level of charges that Mr. Brooks was pending on for this bail?
Objection. already
Overruled.
made a ruling on it.
Overruled. The witness may answer.
All the charges that I see in here are felonies.
To your knowledge, was this bail in full force and effect on November 21 of 2021, sir?
Objection.
Overruled. You may answer.
Yes, it was.
And in the middle of the form, do you see the conditions of bail that were set upon Mr. Brooks?
Objection, leading.
Overruled.
Yes, I do.
And I'm looking under paragraph B, the third bullet. Do you see that?
Yes, I do.
Could you please read that bail condition to the jury?
Objection, leading.
Overruled. The witness may answer.
The state defendant shall not commit any crime.
Thank you. Move to admit number 88, Your Honor.
Objection.
Exhibit 88 is received.
Like to display for
It was
the,
already speculated to. How's that coming into evidence?
Overruled. And permission to publish.
I'm sorry, I did not seek to publish this, Your
Oh,
Honor.
all right. Turn that
I
on.
request a legal finding of fact for that.
The objection is noted. It's overruled. Continue. Attorney
I
Opper.
love how when
Thank you. I'd like to display for the
the judge
witness
said during
only
opening
exhibit
arguments
89.
he can't mention subject matter jurisdiction. She's like, I already knew that, Your Honor. I wasn't gonna. It's like, yes, you were. Don't
Duh.
lie to me.
Go ahead.
Sir, can you
Like,
please
duh.
identify
On the way to the
89?
bathroom.
Why would I do that?
Objection.
Hadn't been proven on the record.
Overruled.
Relevancy.
Overruled.
He's got a point.
This is a
No.
This is speculated.
This is
It's
the
on the
big lady
record.
stipulated to. I
it's so
love
on-
these.
It's so on the
I love
record.
this
She
subtitle.
filed it.
Noted. It's overruled. The witness may answer.
I love the subtitles. They're so good.
Noted. Overruled.
This is what the big lady stipulated to.
This is a bail bond through Milwaukee County Circuit Court for Darrell Edward Brooks with the date of birth of 2/21 of 1982.
Is this a different case than what was displayed in Exhibit 88?
Objection, leading.
Overruled.
Yes, it is.
Are you
How
able
can you
to
say
make any observations
I was
about
jumping
the
bail
level of charges
if I didn't jump
related to this case, sir?
at all? I just walked.
Objection, leading.
Overruled.
Bail's just his nickname for the prosecutor.
It appears that there's 4 charges, 2 of which are felonies.
Okay. And on the bottom of the form, can you tell the date that this bail was issued?
Objection, leading.
Overruled.
Say it's 11/11 of 2021.
The directing your attention again to that same location in the middle of the page under paragraph B, the third bullet. Could you please read the conditions of release that were set by the court in that case?
Objection, leading.
Overruled. The witness may answer.
Officer Tackleberry's expression has not changed since day one.
To your
No.
knowledge, sure, was this bail in full force and effect on November 21 of 21?
Objection, speculative and leading.
Overruled as to both. The witness may answer.
Yes, it was.
Finally, sir, I'd like to put up one last item for you, or 2 items. 1 second, please. I'd like to display for the witness only Exhibit 13.
Hey guys, check the private chat in just a second.
Objection, what's the relevancy of this? How does it say any foundation to testimony?
I'll give the state some leeway to establish that. Go ahead.
Thank you. Sir, do you recognize can you tell if Exhibit 13 is a video, sir?
Yes, it is.
Okay. Have you seen this video before, sir?
Objection, leading.
Overruled.
Still relevancy. Where's the relevancy?
The state is asking the foundational questions, the objections of the premature. I'll take it under advisement. Go ahead, Attorney Opper.
Yes, I have.
What does this video depict?
Objection, leading.
Overruled. The witness may answer.
Objection, speculative.
Overruled. Go ahead.
This video depicts the backyard at 4014 North 19th Street in the city of Milwaukee. It also, that's the address of Dawn Woods, the mother of Darrell Brooks. And on the lower left-hand corner, you can see a Ford Escape.
In the lower right,
I move to strike that. How does he know?
The objection's noted, overruled. You can ask him on cross-examination. You can question him about that. Go ahead.
in the bottom right-hand corner of the exhibit, do you see a date and time stamp for this video, sir?
Objection leading.
Overruled.
Yes, I do.
What does it say?
It says 11/21-2021, and then it says 13:26:18.
What do those numbers represent, sir?
Objection leading.
Overruled.
To me, it means that the video was taken on November 21st, 2021 at 1:26 p.m.
And do you believe this video is a true and accurate representation of the events of that afternoon at that location, sir?
Objection speculative.
Sustained, if you could lay a little more foundation.
Sure.
please.
How did you come into possession of this video, sir?
The defendant's mother provided it to us.
And do you know approximately when it was obtained?
Objection speculative.
Overruled.
The evening of November 21st, 2021.
Do you know if the defendant's mother was
I like how we're both not paying any attention to the trial and we're waiting to see what happens in local.
In fairness, this guy's already testified. If it was important, they would have got it the first
the
time.
video was provided?
That's exactly what Brooke said.
Exactly, he's right.
Overruled.
He was right. There's just no
Yes, it
grounds
was.
to exclude him. Is
Do
the
you have any
problem?
reason to believe
Correct.
that the video was altered or modified in any way before it was provided to police?
Also, may God have mercy on your soul for being in this chat.
I don't know what to expect.
Move to admit 13, Your Honor, and
It
permission.
looks like the only rule is there are no rules.
Basically, no porn. That's it.
Noted. Overruled. Exhibit 13 is received. Permission to publish is granted.
For the record, this is a video. It's 49 seconds in duration. We're going to play it in full. There is no audio, and it will be played at normal speed. Oh, hang on. Don't play yet.
I just snorted.
The jurors will let me know when the monitors are displaying
Oh, man.
the video. All right, go ahead.
While this video is playing, Avralian says, Nick, finally catching you live. You've inspired me to get out of my dead-end job, so thank you. Second, can you get on the Rumble people to keep your place in a video? Frustrating to lose your place. That's one of the features they talked about, or I just talked about with them the other day, and I'm hoping that that's something they can get to really soon. Also, I talked about getting the rewind when you join a live in the middle of it. I think it's on mobile that it doesn't work, but I think on desktop it does, which is a new change. So they are working on some of these features. Absolutely.
Detective Casey, were you able to see any emblem on the front grille of that vehicle as it drove away?
Finally, they've done it. They've put me on here.
I would have to look at it again.
Okay, I'm sorry. Let me ask you this.
I can't post
Did
that
you
on.
see any damage to the front end of that vehicle as it drove away?
Objection leading.
Overruled.
I did not.
Okay. I'm going to put up State's Exhibit 14 now, please.
Go ahead. Just to the,
Yeah, just to the witness only, please.
thank you.
Do you recognize Exhibit 14, sir?
Yes, I do.
What is the source of Exhibit 14?
This is a still shot taken from the video.
The same video we just saw, number 13.
Yes.
Move to admit 14 and permission to publish, Your Honor.
Objection, relevancy.
The objection's overruled. Exhibit 14 is received. Permission to publish is granted.
Sir, do you see Darrell Brooks in this photograph?
Objection, I don't consent to being called that name again. for the record.
They didn't.
No,
they
that's
actually
overruled.
didn't call you that name. He keeps making these
Yes, I
objections,
do.
but it's
Can
like
you
we're talking
identify
about,
or
is that
excuse me,
Darrell Brooks? Not
excuse me.
you.
describe the clothing
No,
items
you're
that you
not
see
that
him
guy.
wearing in this photograph? Oh, it's not in the jury box yet. I'm sorry.
You can state your objection, though.
I've never wanted to hear somebody say their own name more than Darrell Brooks in
Yes.
those interviews. And while he's laying on the ground, it's like, what's your name? Say it.
Bruni,
Say your name.
Red t-shirt.
I want him to say it
blue
in court.
jeans.
He did during the interrogation videos. He had no problem with being called Mr. Brooks and Darrell Brooks.
Spelling it out.
And
Only after the soft sits got a hold of him in
date
jail.
timestamp for this photograph, please.
Dude, this is how you beat the life in prison without parole or rap.
2021 at 13.
That's why I'm still here.
08 hours.
And that's what time, sir?
Objection, leading.
In, on the 12-hour clock.
Objection, leading.
Overruled.
That would be 1:26 p.m.
All right, thank you. Have any other questions, sir?
Thank God.
You sure this time?
I just want Brooks' opening argument before I have to go teach.
trust.
That's all I want in the world. I just want it. I've been waiting and waiting and waiting. Give me your
They have
opening
to-
statement.
They have to at least have some sort of mechanical expert come and testify that the vehicle was working properly. They haven't had one of
You
those
see
yet.
anyone driving the vehicle?
Yeah, they did.
Did they?
Yeah, they had that yesterday.
No, I
Oh,
do not.
good. Must have
Yeah.
been in the afternoon when I missed it.
Yeah. He was like, did anything stop this car from hitting the brakes? It's like, nope, brakes were working fine.
Yeah.
Do you know
I
if
mean,
anyone's in the vehicle
that was brutal.
Yeah.
at the time that you see it pull away?
I would assume based on my training experience that when the vehicle pulled away, that there was someone inside the vehicle, because in order to move a vehicle, you have to manipulate the controls, the shifter, the brake, the accelerator. So my assumption is that someone is inside the vehicle doing that.
That wasn't the question. Did you see anyone in the vehicle?
I object, Your Honor, that was the question, and he's already asked and answered. The question is, anyone can be seen.
The objections. I'm not sure what the objection was, but the answer may stand. You can ask your next question.
Let's go back to Exhibit 175 and pull that up for the witness.
I have to
Would the
remove
state
that
please
one.
pull that up? Witness only or published?
Publish.
Okay, thank you. Go ahead. Jurors, let me know when it's in the jury box as well.
Remember when I said it feels just like old times? It really doesn't now that I'm in the locals chat. It feels different.
Just-
It does- feels a little
Feels like-
different.
Just
Feels like the
testified
much older times.
Yeah.
that this was the alleged defendant. How do you know that? Can you see a face?
Which question are you asking? Those were two.
Can you see the face on the circle
You see my face? I mean, this guy's face.
exhibit?
In this clip, I cannot see the face of the person that is circled.
So how do you know who it is?
I can tell who that is because I have watched this video in its entirety, and I can tell that it is you based on all of my contacts with you.
So why were there not any other exhibits that can give credibility to you positively identifying the individual in this video?
Objection, argumentative,
Grounds.
compound.
Sustained as to the form of the question.
Grounds.
Is it fair to say that this is the only exhibit photo from the video?
clarify, the only one that is shown today, or the only one that has ever been taken?
The only one that's
ever
the only
exists?
one that's
Could you clarify,
being
please?
shown right here today.
Why
This is
wouldn't
the
they
only
just
one
play the
that
video?
is an exhibit being shown here today.
If he's arguing this
is
isn't
the only
him.
one that we've shown today.
And you can tell just from this exhibit exactly who that individual is.
I don't believe that was my testimony.
I'm asking the question.
From just looking at this, no, but I know from looking at the entire video that it's you.
We're talking about this exhibit that's being shown right now during your testimony right now at this moment.
Let's
Just
get
working on
crazy
my
right
Halloween
now.
costume.
Could you ask
Once
your
I got
question,
his
please?
accent fully
I'm going to
down,
object
it's
as
on.
answered.
Sustained as to
You
the
get a
form
red
of the question
SUV?
as well.
Won't cost that much.
Would
A late model
Yeah.
Ford
that
Escape.
on this exhibit 175 that they're looking at right now,
Driving around
that
my
you
neighborhood.
cannot tell who the circle individual is. Would that be fair to say?
That would be fair to say.
Can you clear the circle?
Thank you, Madam Clerk.
Yeah, she always makes sure to say please and
Do
thank
you
you.
recall what
I did for my
date
son.
you viewed this video, as you call it?
I have viewed this video multiple times. I don't recall the specific dates that I've seen it.
Was it relatively early on in the investigation?
There have been multiple times that I've watched this video, some of them early, some of them as late as yesterday.
Do you recall seeing this video the same night of the incident or in the days following?
I did not see it the night of, but it would be the days following that I have seen it.
And at that time, did you have knowledge of who that vehicle belonged to?
Yes, I did.
And did you have knowledge of the usage of that video? I mean, the usage of that vehicle?
I'm not sure that I understand the question.
No, he
I
doesn't
don't either.
It's fine.
Knowledge of the vehicle.
Objection vague as to time.
Sustained as to the form of the question, if you could limit or perhaps direct him to a specific time frame regarding the use of the vehicle.
At the time of the incident.
Yes.
And can you clear that? And what information was that?
The information that I had is at the night of the incident that you, Darrell Brooks, were the person that were operating the vehicle.
They love to do that.
Who did you learn?
Yeah.
that? For the record, I don't consent to that name.
Doesn't matter if you consent to
Noted.
it.
For the record.
Overruled.
We know.
Go ahead and answer.
Can you repeat your question, please?
I'm gonna go another route on this.
You didn't see the exhibit, sir?
No, I'm not.
You're withdrawing your question?
Yeah, I'm going another route.
All right, thank you.
The original route isn't working too well.
Steel frame.
The original route was filled with dancing grannies.
I testify that this came from the entire video, correct?
You said that you viewed the video in its entirety, correct?
The entirety, what we recovered from your social media account. I'm not sure if there is a longer version someplace, but
Did you see the video in its entirety? The
remix.
video that this exhibit came from.
yes.
Locals is killing me.
And are these the only two
I stopped looking
individuals?
for like
that you
1 second. I
heard
can't
in that
imagine
video?
what it looks like now.
They are the only two that I recall seeing in the video.
Did you ever inquire about the identity of this individual?
No, I have not.
He's not throwing his buddy under the bus, is he?
Circle.
Always.
Thank you, Madam Clerk.
Because we all
Always
look
blame it
alike
on
to
the other
you.
person
Would it be
because
fair
they
to
don't
say
have a case
that from
against him.
looking strictly at the exhibit that we're viewing right now, that both individuals have the same hairstyle?
It would be fair to say.
Can we
He
clear
is
the-
not going with we all look alike to you, don't we, defense.
clear the exhibit?
Oh, that would be great.
Go ahead.
We go back to exhibit 13. Published.
This is the first time I've watched the trial not on 2x speed, so
Oh yeah, welcome
it
to
hits
hell.
different. It hits different.
Can you play it?
I wish we could
Just-
watch it on
Just
times.
play it. I'll tell you when to pause if that's okay.
Go ahead.
It's not up yet.
Oh, thank you.
You can actually
Wait,
see the
okay.
damn car in the video.
Why are you making him play? What possible benefit would it have to show the audience
Okay, go
or the
ahead. Thank
jury
you.
again that you are the owner and operator of this car?
Reminder, 49
How
seconds.
do you think this would help you ever?
I don't think I'm gonna need the. Well, I don't know.
I walked off screen and then the car drove, so it wasn't me driving it.
Clearly, he's had to dig up his septic tank at some
Pause.
point in the past.
Right there, the individual that you observe. Right here. Do you see them wearing a hoodie?
The person in that photo is not wearing a hoodie.
Do you see a hoodie anywhere present in this video?
No, I don't see a video or a hoodie anywhere in the video.
Can you take the X down? From this angle, it'd be fair to say that you can see the very front end of a vehicle, correct?
That is correct.
Can you see any
Oh.
windows or see inside the vehicle at that time? Or at the time that we're looking at right now?
You cannot see inside the vehicle at this time.
So it would be fair to say that just by looking at what we're looking at now, you wouldn't know if anyone's already inside
This
the
is his
vehicle.
problem. He occasionally has an intelligible line of question.
I'll allow it, the witness to answer.
This is a
Why
whole
would you object
different.
to that? Come on,
I'm
he's
allowing
doing the good thing
Go ahead.
for once.
That is correct. From this video, you cannot
This
tell
is
if
an
anyone
excellent
else is
line of
inside the
questioning.
vehicle.
So it'd be fair to say that you're not sure.
Yeah,
It's fair to say that I am not sure.
They
There you
can't be
go.
scared of stuff like
Totally
that. Yeah.
I mean it's not going to save him, but it's
No.
the right questioning. A defense attorney would ask the same questions.
Correct.
Whoa,
He's
wait.
nailed
I'm sorry.
this part. Good job.
Pull that back up for 1 second.
Oh, wait, this is his Columbo moment. Wait, just one more question.
The state would put that back
Right.
on display,
Okay.
and there you go.
Do
Do you want any
Wait.
more of a plate or just the still?
we waiting for the jury or do they?
It's up.
No, we don't need it played.
Do you need it to go to a certain point?
Yes,
All right, do you know what point?
I'm about to it right now. Looking at this house right here, do you see an address posted anywhere on this house?
In the photo that you circled, no.
So it'd be fair to say that you don't know the address of this house.
That is incorrect.
You just said that you don't see an address posted anywhere in this house. So from the vehicle, strike that, not the vehicle. I'm still looking in the corner right here. From the video that we're viewing right now, do you see an address posted anywhere on this house?
I do not see an address posted in this photo.
So judging by this, well, actually it's a video, but judging by this video, how can you know the address of this house?
Because I've been at this house before to talk with your mother. I've seen the address in front of the house.
Judging by this
Hold
video,
on, you have to let him finish because that was not the question you asked. You asked him how he knew. He can answer. Go ahead, Detective Casey.
I've been at this address before. I've spoken to your mother. I've been in the backyard of the residence. I've seen the address on the front of the house.
That's like the ultimate into tell your mother I miss her, Brooksy.
Your mother's address. The 4014 North 19th Street.
You recognize the house or the address? Because we don't see an address in this video.
I recognize this house to be that address from being there.
And had you already been there, as you say, and talked to people, as you say, before you viewed this video?
I believe that I saw the video first, and then I was at the address.
Then I visited your mama.
So at the time that you saw this video, you didn't know whose house that was.
That would be an incorrect statement.
You just said that you saw the video first before going to the house. Did you, or did you not say that? Would that be fair to say?
I guess I'm a little confused in your question. We received the video. We know from getting it from my mother that she said that that is where she lives. So I knew that this was where she lives when I watched the video. That was clarified for you.
I follow you, but that clarification wasn't stated before. So
That's why it was clarified.
that's fair from the clarification of how you just clarified it. Can you clear
I don't
the
know what
So
that
we're done with
is.
this exhibit?
I do. It proved that that's his car and his vehicle at his mama's house. That's what it proved. Good job there, Darrell.
Yeah, walked into that
We'll
one.
take it down.
You just got to limit him to, you can't see the address, can you? Don't ask, is it fair to say? Don't ask anything like that. You can't see the address. We don't know what house that is.
You made reference to a key
Not,
being
again,
found.
none of this is going to
Did
help.
you yourself find that key?
No, I did not.
Were you at the scene where the key was found at the time it was found?
No, I was not.
That's why we have multiple witnesses, Mr. Brooks.
So it'd be fair to say that you were told that a key was found.
Yes, I was told that a key was found.
Objection, hearsay, Your Honor.
So it'd be fair to say that you went off of what you were told. You actually didn't observe this with your own eyes.
What are you speaking of?
The key being found.
That's his way of saying, what are you talking about?
That's correct. I was told by two officers who I
Thank you for dumbing it down for us.
Yeah.
trust what they tell me to be accurate.
Forsooth. I witnessed the key.
You made reference to there being a couple, what's the word you used, a couple ways to identify individuals. And you stated that you had spoken with the mothers of the alleged defendant's children. That'd be fair to say?
I believe I said I spoke with the mother of 3 of your children.
3 of the alleged children?
Yeah.
How many of yours
At
are
that
alleged?
time, was the alleged defendant already in custody?
Yeah, how many children
Yes, he
does he
was.
have?
I
Would
believe
it be
4.
easier to just use the
Stupid
fingerprints that were already obtained?
Like I said before, the fingerprints was one way. We also verified it talking to his family members that his identity.
Any reason why, or let me back up. Is it fair to say that there was more confirmation needed to identify the alleged defendant at that point, seeing as how the fingerprints were already obtained?
We were just being thorough. We were certain that it was Darrell Brooks that we had in custody based on his fingerprints and other information that we had. It was just a matter of being thorough and verifying the person that we had and the name that he goes by.
Jesus.
It'd be fair to say fingerprints are pretty accurate though, correct? That'd be fair to say?
I think that would be fair to say.
Darrell, you're making it worse.
It would also be fair to say that there wouldn't be any reason why the alleged defendant that was in custody would be someone else. Wouldn't that be fair to say?
Objection, that's compound, and difficult.
Stupid.
The guy's like, the state attorney's like,
Sustained as to the form of the question. Please
That was
rephrase.
very clear.
Sustained as
And where did the interviewing of the mothers of these children take place, if you recall?
I spoke to Jessica Macklin in Iowa at her residence. I spoke to Angel Fitzpatrick at her residence in
Whoa,
Menominee
whoa, whoa, whoa,
Falls.
whoa, whoa, whoa. Can we strike that? Why do the names?
Guys, I got
Have to
wrecked
be
by
stated.
Lady Rackets.
overruled.
All she did was send me a
Question.
laughy face emoji.
His answer may
That's all I
stand.
got
Your
for
request to
response.
strike is denied, and the witness may continue answering.
Is that
Hold
good
on.
or bad?
Spoke to
I'm
Angel
Googling how to
Fitzpatrick in
weave a
Menominee
noose
Falls
right
at her
now.
residence, and I spoke to Erica Patterson a number of times at various locations about you.
You said one of the mothers of these children you spoke to in Iowa.
Correct.
Why would you go all the way to Iowa?
Because initially you listed her as a witness on your witness list for court. So we went there and we wanted to verify what information she might have that she would testify to.
Just for the record,
interesting.
I don't recall listing anyone as a witness, just for the record.
For the record, Mr. Brooks, you can't testify.
For the
This
record.
Well, you
moment,
can.
have an opportunity
It's not
to
yet.
use.
I just
Um,
wanted that clear for the record since what was
Can't be,
said.
it's struck from the record at this point because you attempted to
Actually
testify.
struck from the
The
record.
jury will
I
disregard that.
just wanted the record to show.
The record will not
Jury
show
will
that.
Of doing that. And if
The jury will disregard those statements made by the defendant as
Something's-
that he is not testifying, and it would be improper at this time for the court to receive them.
I don't think a
Go-
record should be
next
made of
question, sir.
something that I didn't do.
What about
Next
subject
question.
matter jurisdiction?
Ridiculous.
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 So you said you went to Iowa to try to find out what would be testified to. Why?
Objection, argumentative,
Grounds.
irrelevant, and calls for hearsay.
Grounds.
Those are all
Sustained as
grounds.
to all things. Next question.
So
Unprepared.
Was that an attempt to prepare for what might have been said?
I'll allow
Fair
that.
question.
Okay, go ahead.
Yes.
3-cat pileup says, I'm a time traveler from the future and I'm
Why
telling you
would
this
there be
case ends in a
preparation
mistrial.
in-
What is your best
involved
guess
in
as to
someone who
why?
might testify on an alleged defendant's behalf?
Objection, argumentative.
Grounds.
Because
Overruled,
the
I'll
bailiff
allow it.
shoots him in the face in the middle of the trial.
We were going to speak with her, so if she came in and testified, there wouldn't be any surprises. We also wanted to find out if there's any background information that she had about Mr. Brooks that would be helpful in our investigation.
So you made reference to not being any surprises. Would it be fair to say that there was a little worry there?
Objection, argumentative.
Grounds.
Sustained as to the form of the question.
What surprises were you referring to? What do you mean by surprises?
Brooks, wrap this up. You can get your opening statements. Come on, buddy.
Witness is not expected to testify. It's wholly irrelevant.
Well, he opened the door by putting the name on the record and saying where you went.
I will allow one more question on this. Go ahead, you may answer.
Could you re-ask the question, please?
What do you mean by making sure that there were no surprises?
We wanted to make sure that there wasn't any information that we weren't aware of that may come up later that would be helpful in the trial.
Do you recall making an attempt to interview the child
Objection, relevance.
who was 7 at the time?
Sustained as, next question, please.
Reason for the sustain, Your Honor?
Not relevant.
Well, the question was asked, does he recall?
Sustained. Next question, please.
Grounds for the sustain again?
Relevant.
How's it not relevant?
Keep going, sir.
Did you interview the child?
Same objection.
Grounds.
Sustained.
Grounds for the sustain?
Relevant.
Why would you ask to interview the child?
Your Honor, objection. This
Sustained.
entire line of questioning is inappropriate.
Sustained.
Oh,
Move on.
I would
Mr. Brooks.
object that.
I'm
Trying to
objecting
interview a
to her
7-year-old
objection.
child is
Sir, move on, please. 90611. It's also not relevant. Assumes
Very
that's not an
relevant.
evidence.
it was a tricky move.
That was a tricky move.
Jesus Christ.
You made reference to, in regards to Exhibit 88 and 89, which were documents from an entirely different county. Do you work for Milwaukee County?
No, I do not.
So how did Milwaukee County, which is a different county, come into your investigation in Waukesha County?
You may answer. With the understanding there are some limited pretrial rulings that still are in play. Go ahead.
During the normal,
I'm sorry for interrupting. I started off by saying in regards to Exhibit 88 and 89. That's how I started the question, just for the record.
I know. I'm reminding the witness of the pretrial rulings.
Okay.
during the normal course of an investigation, we do background on a person to see if they have any open cases or any information that would be helpful. There is a computer system that displays what cases or charges are open for a person, and it is relevant because if you are charged in one county and you violate conditions of bail, you can also be charged in another county for those violations.
And in reference to having charges in one county and potentially being charged in another county, in reference to that,
God, I'm so jealous.
ASMR whiskey.
Oh,
wouldn't you essentially have to violate the conditions in one county?
I need it. It's my medicine to help me through the Brooks trial.
That is an inaccurate statement.
This is brutal. Brutal.
It's literally doing the
You
opposite
being
of
in
help.
law enforcement for a very long time, it would be fair to say that you're
People on my streams have been asking, like, do you think this is working? Do you think he's creating reasonable doubt for the jurors? I'm like,
I've heard the term before.
I honestly think,
And
like,
what is
how do
your-
you feel about him? And they're all like, we hate him.
That
He's the
term mean?
worst. It's like, they probably feel the same way, is my guess.
Knowledge.
But worse, because they can't turn off the monitor and walk away.
Literally, they're just stuck here listening to this day after day.
So when did you
It's
become a lead
miserable.
investigator in this matter?
they can't, like,
That was about 8:30 p.m.
I
on
can't even
November
imagine
21st,
how
2021.
fast for 70
So same night.
charges the jury's going to come back on
Correct.
this.
Well, you figure it may take them about a minute per page, so give them like an hour and a half.
The command staff or Lieutenant Jerry Habanik.
Do you recall why you were tapped to be the lead investigator?
Because I was the most qualified person and had the most experience to take care of it. That's what I've been told.
Who told you? Who do you
Any
work
other reasons
for?
besides that?
The plaintiff.
Also, because I was at the parade route a little bit earlier and I had the most information out of anyone, it took a little while for the other staff to come in. So I already had a little bit of a head start with the information that I already had learned as being there at the beginning.
And
It
that
almost
would
looks
be
like
in
the
reference to information
Rekieta court
that you
clerk
had
is on a
more
green screen.
knowledge of than anyone else at that
Like she's
time.
got the whole trial green screen behind
Would
her.
that be
She does.
in reference
It's
to
me.
having an
I
interaction with
pre-recorded
the
this segment, but I'm actually there
vehicle
in
at
green
some
screen.
point?
I would say as the totality of the situation, I was there when the car first went through. I know what the radio traffic was for taking Mr. Brooks into custody. There's also some decisions that were made early on how to proceed with the case. I was also on scene downtown and took control of the crime scene initially. So a lot of those decisions were made even before our command staff started coming in to take over lead on the case.
You referenced you were there at the beginning when the vehicle first entered in the parade. What do you recall about when the vehicle first entered the parade?
I remember a horn beeping, red Ford Escape driving around, and then you driving into me and not stopping when I pounded on your hood and window.
Driving into
Jeez.
What do you mean driving into you?
I meant that I was in front of your vehicle contacted me, pushed me off to the side, and continued driving without stopping.
Were you injured in this incident?
I was not injured.
Whoa.
And you made reference to a horn beeping. What do you mean a horn beeping?
I mean,
You
a
mean
horn.
the vehicle was beeping its horn?
Well, what the fuck
Yes,
is
the
this?
vehicle was beeping its horn.
It's not good
Would
for
be the
you.
only time a
Darrell.
vehicle would beep their horn.
Objection,
Grounds.
speculation.
Sustained.
Peter, I don't know what to
Also
think about this.
speculation.
I don't know what to feel about this. So much confusion.
I look a lot happier than you in that picture.
Do you know why the vehicle was beeping their horn?
Same objection.
Do you know why you would beep
Maybe
your
you
horn?
take a sip of
No,
water
so
before you
he can
spit
answer that
next
question.
time.
Could you repeat the question, please?
Do you know why the vehicle was beeping its horn?
Oh.
I imagine that the driver was angry and wanted to get through the crowd.
I do not consent to being
And how did you come to
put in
that?
that situation.
You don't consent.
I've been
You
driving
think
a
I
long
did?
time, and a lot of times people get angry, they're late, they beat their horn at you in a way that is because they're upset and they're trying to get past you.
Do you know that for sure?
You asked me my opinion.
Yes, I
Locals
did
just
ask your
brought up a really
opinion.
good
Now
point.
I'm asking you, do you
Uh,
know for sure
If
if
you don't want this witness
the
to be
driver of the
cumulative,
vehicle
stop
you
asking so
observed
many fucking
was in
questions.
fact angry?
And there are also people saying, I didn't realize that Brooks
I assume
hit
that
out
he
of his
was.
car. I didn't realize that either. But
So it'd
luckily,
be fair
Darrell
to say
Brooks
you
brought
don't
it
know
out.
for sure.
I do not know for sure, but that is my opinion, is that he was angry.
And at that time, you had no knowledge who the driver was. Would that be fair to say?
Well, I had knowledge because I saw your face. I did not know your name
Did
at
you
that
know
time.
who the driver was? No, meaning had you had any prior interactions with them before this incident? That's what I mean by no. Have you had any conversations with him, talked to him?
Hold on.
saw him?
Compound question, ask one.
I was just giving clarification of no,
You
what I
need
meant
to-
by
It's
no.
a compound question. Please rephrase.
No means no. Haven't you
Before-
learned that yet?
before you
Hashtag
observed
me
this
too.
Vehicle, as you say, and this driver that, as you say, did you know them?
I have no memory of meeting Mr. Brooks before that afternoon.
So it'd be fair to say that you're assuming something that you don't know. Would that be fair to say?
Objection, compound, vague, and argumentative.
Sustained.
Grounds.
Sustained is to the
Grounds.
compound question.
How would you know how someone's feeling if you don't know who they are?
I've identified the
Honor,
real driver.
He opened the door to this. It's asked and answered. The witness has given his opinion. It's clear.
Grounds.
I object. Improper question.
Grounds.
I will allow the witness to answer why he came to that conclusion. Go ahead.
Like I said before, I've been driving a long time, and a lot of times when people are beeping their horns, it's because they're late, they're angry at something happened, and that's why I concluded that the person was probably angry.
So would it be fair to say that another reason why a vehicle would beep its horn would be to alert people to the presence?
Objection,
Grounds,
irrelevant speculation.
grounds.
Definitely
I'll
speculation.
allow it. Based upon his training and experience, he may answer.
It's a possibility.
But then what do they usually do if they beep their horn and the person doesn't stop in front of
Yeah.
them? What do they do next in your
Did
training
you-
experience? They usually
Did you
stop,
beep
right?
before the vehicle approached you?
Yes, I did.
You made reference to, and I'm referring to the ring video obtained in exhibits 88.
This is literally the least important witness testimony in the entire trial.
Ring video obtained in exhibits 13 and 14. You made reference to obtaining that the same night of the incident. Do you recall saying that?
Yes, I recall saying that.
And it would be fair to say that you yourself have been present for all testimony. Would that be fair to say?
That is not correct.
How so?
I was sick one day and I was not here.
Well, I'm referring to, let me clarify. Maybe I wasn't clear enough. Pertaining to all testimony since trial began, you've been present for all testimony. Would that be fair to say?
I believe I've seen most of it.
Do you recall testimony of
No, nobody
and I'm referring
recalls.
to, again, so clear for the record, exhibits 13 and 14, ring footage that was obtained by the owner of 4014 North 19th Street that you testified to obtaining the ring footage.
Maybe they'll play the
same
video
night.
on redirect. That'd be
You're
so
aware that-
amazing.
Well, let me back up just a little bit. How were you able to obtain that ring footage?
I think that door was opened when he
There
was
was
trying to act
officers
like
that
it wasn't
went
him
to
on
Freer
direct with his
Hospital
objections, and they
for
didn't do it
Brooks.
then. So
Mr. Brooks's mother was working. They spoke to her, and she's the one that alerted to them that she had ring video at the house and offered to remotely download that video for them.
And were you there yourself?
I was not there myself.
When did you yourself speak to the owner of that home?
The last time that I spoke to Dawn Woods was on August 8th of this year. I may have spoken to her a few times before that. I don't recall the exact dates.
I'm referring to the first time that you spoke.
I don't
The
recall
very
the
first time.
I don't recall the first date.
I'm about to cancel
When
this
that
damn
was.
locals chat.
And you did just make reference to an August 8th date. And what was the extent of that conversation?
Objection calls for hearsay.
Grounds?
Sustained. Hearsay.
that was a good one.
Oh,
I was
was it?
looking at
Tony
something
Curtis.
else. I was looking at something else
The
right when I
August
looked
8th
back.
date
That's what I
that you
saw.
referred to, was that in any way follow up? Was that follow-up investigation?
Follow up to what?
Well, you stated that you had spoken previously before the August 8th date. So the question is, was the August 8th date follow-up to the investigation that you were already actively lead of?
I mean, everything is related to this investigation. The
So-
investigation continues every day. It's not end. It will not end until this trial is over.
So what follow-up was needed at the time of the August 8th interview?
So now it's positive. He's just trying to delay this
I
trial.
don't know,
Like,
Stuart.
none of this matters.
Objection still
Yeah.
calls for hearsay, Your Honor.
Sustained.
God damn it, locals, stop
I mean, you
tweeting me
talk
pictures
to-
of the Lorax. I'm
Yes,
not the
sir.
Lorax.
Every time we spoke to her, we got different information, and at that time, we were following up with your niece and nephew, what their testimony would be in this case.
What testimony are you referring to? Because
I haven't
I don't
testified.
recall any nieces or nephews testifying.
I don't think I'm allowed to say it.
Oh, interesting.
Ooh.
I think this line of questioning is irrelevant, Your Honor.
Or is
I'll
it going
sustain
to a
the
motion
objection,
limiting?
and an appropriate break, I can address it further if need be.
Is there a
Please move on to
deposition of one of
any
those
topics.
kids that he's referring to?
You made reference to people who were injured at the parade inadvertently. You recall that?
Yes, I do.
To your knowledge, were any of those charged?
My testimony before is that those people's cases were not charged.
And were they seen as victims?
Going to object to the form of that question. I think it calls for a legal conclusion, Your Honor.
It does not.
D-Bear66. I'll
Asked
answer
to-
your question
asked to his
on
knowledge.
a break. I'm going to get to super chats as soon as the court has a
I'll
break.
sustain the objection as to the form of the question, if you could please rephrase.
I'm gonna go a different route.
Oh, is this one not working for you?
There's more routes.
A route that doesn't involve the dancing grannies, perchance.
You know, if you would have gone a different route, we wouldn't be here.
Or if he would have just stopped like he should
All right, here
now.
D-Bear66 says, hey, Nick, if I subscribe to a high school football live stream, can I add commentary if there's none on the original stream? Thanks for you, man. It's a tough question. It's really a tough question. Is the commentary you're adding sufficiently
Do you recall?
transformative is part of it. But there's a lot that goes into a sporting event
Do
and
you recall
what will actually transform it into something different than what it is.
Warrant to the Waukesha County Jail on July 1st of 2022?
Yes, I do.
Do you recall what that was for?
Yes, I do.
And what was that for? Can you state for the record and for the jury?
It's for Mr. Brooks's jail cell.
And why did you serve a warrant for a jail cell?
Your Honor, I object pursuant to
Is he serious?
legal rulings previously issued in this case. I don't think this is relevant.
I'll sustain the objection. It's not relevant. I'll certainly take it up at a later point if need be.
He wants to talk about serving a warrant on his jail cell?
What was the warrant pursuant to?
I sustain the objection. Next topic.
Does he think the jury's going to feel bad for him?
Yeah,
I'm trying to figure out where his angle is with some of these questions. I think he's trying to
And
make the
directed
jury
not
think
to
he's getting
answer. We'll
steamrolled,
take it up separately.
which he's not.
I'll have you continue with your cross-exam and I'll take it up later.
You could probably read 3 super chats between each question, Nick.
I hate when he does this because here we go. Excelsior says, is all this leniency in order to stop any possibility of an appeal going through? Would it be overall faster and cheaper to have one long, painful trial or one speedy trial and a lot of appeals? One long, painful trial, because it's going to be a long, painful trial. There's 70-something charges. There's just going to need to be a lot of
You made
witnesses
reference to
get everything on there. But yes,
this
ultimately, they're
vehicle
being deferential because
driving into you.
they don't want any
The
appearance
state
of
you were not
impropriety or
injured. Did you
taking
file a
advantage
claim
of
in
a
this
pro
matter?
se idiot.
No, I did not.
Do you consider yourself an injured party in this matter?
Here we go.
No, I do not.
Might as well mute it. We could reenact this part.
Do you yourself know if anyone filed a claim in this matter?
This is good. He just signals right when the testimony is going to
Can you be
end.
more
so thank
specific?
God
True.
for it.
Do you yourself know if anyone filed a claim in this matter?
This is something that would not be allowed with criminal defense lawyers. If it was totally irrelevant stuff,
Just
he's
in
bringing up
general?
every time. The judge would be like, no, you're not asking those questions.
Whatever your interpretation of that will be.
I would say yes.
And do you know what that claim was?
I would imagine that there was a lot of injuries from the people. A lot of people had very
Objection,
extensive
speculation.
medical bills. I imagine that they would file a claim with their insurance company to have those bills paid.
So you had knowledge of
Wrongful death is one
what was
claim that
filed
comes
to
to
their
mind.
particular insurance companies?
I have no knowledge, but my assumption is that they would have filed those bills.
So it'd be fair to say you don't know for sure.
That was my testimony.
Is that the answer?
Yes.
At least you know it's ending at this point.
As lead investigator for this matter, or are you,
Come on, Judge.
to your knowledge, aware of any
Plaintiff.
GoFundMe
What?
type of things?
Objection
in relation
relevant?
Yeah, yours. The BLM set up for you.
Do you mean as it relates
to, as it
to
relates to the incident?
overruled the witness may answer?
I have no direct knowledge, but I assume that there are some GoFundMe pages out there. It's typical in something like this.
And what do you mean by typical? You've seen this before? Is that what you mean by typical?
We have a very loving
How
and
is this
caring
relevant?
community
I
where
don't
a
get
lot
how
of
this is
times when bad
relevant.
things happen to people, people pull together and offer financial assistance to help people.
Yeah, the people of the community are doing what
Is
they
it fair to
can.
say that
Kind of like these jurors,
there's a
people
lot of
from this
communities
community
like that across
should do
the
the right thing. It's like,
Yes, I think there are.
Bye, lovely.
I'm not leaving yet, Nick.
It would be fair to say that you've worked extremely close with the district attorney's office during the entirety of this matter. Would that be fair to say?
The district attorney's office has been involved in this investigation since the night of, so we have worked closely.
So would it be fair to say extremely close, seeing as how you've been present for the whole trial pretty much?
Can you define extremely for me?
I would like you to define it extremely.
I'll answer yes if that helps.
To your knowledge, do you know if it's typical for a lead investigator to sit right behind the prosecution table at a trial?
Yes.
Sometimes they sit next to them.
That happens in most larger cases, especially a case of this magnitude. There would be a court officer.
Oh man, just say you've been tried on several occasions. You know the answer to that question is yes.
I've done this multiple times before.
And are you the only detective in the investigation that has that honor?
Objection vague.
Grounds.
Sustained as to the form of the question.
Are you the only detective directly involved in an investigation that sits with the prosecution?
Talking about this case or any case?
This particular
or-
case.
I'm sorry, you interrupted me. Could you repeat that, please?
I believe he said this case.
I'm referring to this case, yes.
Could you re-ask the question, please?
Are you the only detective actively involved in this investigation that sits with the prosecution in reference to this case?
Yes, I'm the only person, the only detective that's sitting with the prosecution during this trial.
If only he had asked to have him
So would you
excluded
explain
from
who
the
other
gallery.
officer is in the blue suit over here?
Objection to the relevance, Your Honor.
Grounds.
Sustained.
I just want to know his role.
Sustained. Next
Reason
question,
for the
please.
sustain.
Not relevant.
He's been in the courtroom the whole trial. Is it not relevant?
Mr. Brooks, next question, please.
Nobody knows who he is. That should be known. Nobody's
It's
sitting at
not
that back table.
relevant to
I
the
don't even
issues
have a
that the
back
How
jury
did you
needs
let
to
him do
determine. Next question, sir.
Just don't get it.
Action, we're telling.
Wish judges would ask me to do things in
So
court.
let's asking. You know what the other one would entail.
Do you have a question, sir?
Yeah, I do. I would like to get to it. Thank you.
Please do so. Thank you.
I've just given up counting the number of times we'd all be locked up in jail if we did anything remotely close to this.
And that's the funny thing, Jeff, about this is he is locked up in jail. So the judge is like, have at it, bud.
So seeing as how you sat with the prosecution for the entirety of this matter, it would be fair to assume that you know who the plaintiff is in this matter.
Yes, I do.
And who would the plaintiff be in this matter?
The state of Wisconsin.
Is that an entity or a living human being?
It's an entity.
How can an entity file a claim?
Objection,
Grounds.
legal conclusion.
Grounds.
Sustained.
You are aware that only a living, breathing human being can actually
Correct.
file a claim. An entity cannot walk into anywhere and file a claim if it's not even a real person.
Objection,
no.
You're aware of
strike,
that, right?
People have thought about that before you, Mr. Brooks, and
strike the
you can't do
statement.
that.
by
The interesting
Mr.
thing
Brooks
is,
also
even if we went with
object
that
to the
and we went with the
question
state of
that was asked
Wisconsin
at
as
the
an
end
entity
is
that can't file a
irrelevant,
claim,
argumentative, and calling for a
every
legal
entity
conclusion.
has the
Objection
right
is
to
not
be
calling for a
represented
legal
by counsel
conclusion
to
in
file
any
the
The
way.
claim.
court
And the
sustains
has a
entity
PR.
doesn't have to show up.
the request to strike the
There's
statement
corporate
statement.
reps.
Mr.
That's what they
Brooks
do.
are granted, or the request is granted, the jury will disregard the statement and the question asked for all of the reasons indicated by the stated, also as a misstatement of the law.
All of the
I
reasons.
object to that, Your Honor.
Your objection is noted. I'm going to have the jury stand for a second. They've been sitting for quite some time, and then you can.
There you go, guys. The jury is
I'll
bored
take
out of their
exception to that
fucking
ruling.
mind.
Takes exception to that ruling.
Juror may be falling
And would
asleep.
like a legal finding of fact.
Your objection is noted. It's overruled.
And that's a judicial determination.
Not a time to argue, Mr. Brooks. Just
I thank you. Be seated. Go ahead, Mr. Brooks. Please continue with your questioning.
Have you ever had any interactions with this entity, state of Wisconsin?
Mr. Brooks.
Biblical
next
knowledge.
11, I'm not going to allow the witness to answer. It's vague.
There was no objection.
Under 90611, I shall exercise reasonable control over the mode and order of interrogating witnesses. Please, next topic. These questions we addressed during the initial cross-examination of this
They're
witness.
gonna keep coming up.
And I determined at that time that they weren't relevant. So next topic,
They're gonna
please.
keep coming up.
Under 90611, sir, please move on to a new topic.
They're gonna keep coming up.
For the cross-examination, I will end.
Do you see the state of Wisconsin present in the courtroom today?
totally ignoring the judge.
Grounds.
Irrelevant.
Sustained. Final warning, sir. Next topic or the cross-examination, I will.
You
Bring it
don't
to an
gotta
end.
keep doing that, Your Honor. You don't gotta keep doing that.
It's my responsibility, sir, over this trial.
I'm informed. And
Thank you.
And I
Next topic.
respect that,
But not
but it's
really.
relevant for the jury to know the truth. They deserve to know the truth.
Move to strike, Your Honor.
Granted, the jury will disregard
Objection.
those last statements. They're
Objection
not
to that.
relevant. Mr. Brooks is not testifying. They misstate the law.
I object to that. That's not lawful law. It's
Noted.
truthful.
Not lawful
All right,
law.
under 90611, I am now stopping the cross-examination. Any redirect by the state.
Objection to that. And I would like
Noted.
legal finding of fact.
Attorney Opera, any
It's
redirect?
delayed argument.
Very briefly, Your Honor. I would
He didn't
like-
have the argument at the beginning, so he's going to have it now at
Witness
the end.
only exhibit 178.
Objection.
I haven't seen the exhibit yet, so I'll take
Well,
it under
I'm
advisement.
objecting still because the
You may show it to the witness.
there needs to be an answer to why the jury's not being told information that they deserve.
Ugh.
Your
Kick it
Honor,
out
I
of the
move for a
courtroom.
bad court
Your Honor, for the
thing.
record, this is a video. I'm going to play about the first 5 or 10 seconds for the witness to identify it before moving on, please.
Oh, please
And
be the music
this
video.
seems- there's objection because this seems like a whole new exhibit. This was never mentioned before. It was never.
I haven't seen it. I can't rule on
Whole
it.
new
So let me
exhibit.
see it, and I'll
When
take
you
your
become an
objection
exhibit,
under. I'll
it
take the
was never an
objection
exhibit
under
before.
advisement.
You can enter a new
I
exhibit
haven't
on
seen
redirect.
this
You
in
can.
any of the exhibits
Except
that I
for the
have. So how
foundation.
could it just be created now and be made an exhibit?
The DA is
Go
so
ahead.
I
annoyed.
have all the exhibits.
She's
Go
like,
ahead, Attorney Opera. I haven't seen it yet. There's nothing on my screen that I can see. I see it's now playing.
So now we just create exhibits now.
oh my
I
God.
have all the exhibits, and this was never in it. Oh man.
She's trying to decide if she's going to laugh or scream.
Sir, do you recognize what's contained in State's Exhibit 178?
Objection,
Overruled.
relevancy,
Overruled. Go
leading.
ahead and answer.
Yes, I do.
What is it?
Objection, leading.
Overruled. The witness may answer.
What is it?
I'm still gonna object. Houses.
Mr.
I have
Brooks, I
all-
ask that you
I
honor
have all
the
the.
ruling that
I
I've
have
been
all the
made.
exhibits, though, Your Honor. I have them
Mr.
all.
Brooks.
They were provided to me, and this was never in the exhibit. So how could it just be made an exhibit?
I'll take
just
this
out
up
of the blue?
outside the presence of the jury, but I'm gonna allow
Can
it.
that, can that be stated for the record? Can that be explained?
No, the jury will disregard.
I think it's the music
statements made
video.
By Mr. Brooks, they're not evidence, and the statement
So this
continue.
exhibit shouldn't be evidence then, because it
Mr.
didn't
Brooks, the
exist before
objection's
today.
noted, it's overruled, go ahead.
There was a still photo shown before of Mr. Brooks
This is
standing in front of the Ford Escape. This is the video in which that still photo was taken from.
Yes.
You could-
Objection.
Overruled. The witness may answer. I'll give you the opportunity to question him about it.
Is this a music
When the
video?
state's done asking the questions, go ahead.
Is my dream about to come true?
Where'd you get this video from, sir?
Objection leading.
Overruled, the witness may answer.
From Mr. Brooks' social media account.
You're gonna play it.
Your Honor, move to admit 178 and permission to publish.
Objection to the relevancy.
I'll
And
find
still
that's
that's how
relevant.
it's
I'll
obtained.
receive exhibit 168. Permission to publish is granted. For the record.
It's 178, Your Honor.
No, could you please tell me the length of the video?
The length is 2 minutes, 33 seconds. We're going to play it
Sounds
in
like
its
a music
entirety, but
video.
without volume, Your Honor.
Oh
All
no!
right, thank you.
Oh damn it! Oh, I'm
And,
so
uh,
pissed.
I object to that. And I would like to make.
I object to that too.
We'll do that outside the presence of the jury, but I will allow the state to play it in its entirety without
Your Honor,
audio.
I have all the exhibits. They were provided.
Mr. Brooks, I'll take that up along with the other two issues I still need to address.
But how can you play something that's not, that I didn't?
Mr.
even
Brooks,
have?
I'll take that up outside the presence of the jury.
This
Your
is
objections are
mind-boggling.
noted.
This is
It's
mind-boggling.
overruled.
Mind-boggling.
Mind-boggling.
Actually, Your Honor, I changed my mind. I would like to play the audio, please.
Yes.
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 Mind-boggling.
I want to have it played first without, and then I'll make a ruling and I'll take that up.
No! Come on, you bitch! Play the audio.
We need to identify his voice. He said it wasn't him.
So we will play the entire
It wasn't me.
video, Your Honor, 2 minutes, 33 seconds.
Oh boy.
Objection to that. Why does the whole video need to be played?
Because it's that
Why?
good.
This
Because
is
he's so damn
justification.
proud of
It's
this.
relevant. You questioned the officer
Math
about
boy,
it.
fly.
You
I
questioned this
question him
detective
about.
about
I
his
question him
knowledge.
about.
Come on, give him some royalties. He's gonna need some commissary.
The video wasn't even in
This
the
is
exhibits
so
that
I
I
would
was.
bad.
super chat the DA $500 right now if she'd play the audio.
Oh my gosh.
Actually didn't even receive them. They
Mr.
were
Brooks, please
obtained.
stop. The jury will disregard his statements.
That'd be funny if Law and Cut got a copyright strike for this.
Yeah, there's the car.
Yeah.
So, and that's where like asking questions like, well, you see the back of his head, you can't prove that it's him and all that stuff. This is where it backfires when you know very well, as do they, that that is in fact you.
He doesn't fully understand the opening the door thing yet.
Correct.
Yo, did you see that transition? Oh my God, I missed it the first time. He teleports in like that. Oh, God. Who's his editor?
Ryan, the editor, needs to step his fucking game up.
Yeah, Ryan, get with this program.
I'll address that later.
Fuck.
Like same tattoos. I mean, it's just like he's gonna probably talk about maybe how this guy has long hair.
Well, he's already done that the first
Oh,
couple
yeah.
days.
This
like-
is redirect, isn't it?
Oh, yeah,
he,
it's
he doesn't
over.
even get to respond on this.
Correct. Correct.
Was it like it's like almost like he knows sign language?
This isn't Rittenhouse. We're not going to get redirect, recross, redirect,
Yeah.
redirect, recross. God, please, judge, rule on this and play it with audio. Do the chat a favor. Don't you
We
know
have to hear his
thousands are
voice. We
watching?
need to hear his voice. Confirm it's him.
Oh,
I mean, how damning is this, dude? It's like anything you may have felt bad for this guy holding up guns and chewing
look
on
at those
cash.
transitions.
It's like,
The green screen is sick. That's
him
what you should argue. It's all green screen.
Let him catch a gun charge for this too, for that Mac 10 he keeps waving around.
oh,
I said, chat, we're going to play the audio at the break. We are going to do that.
let this be a lesson to everyone who may think this is cool when you're in high school or something. Not a good idea.
I think it's cool now. If anybody has a link
ahead,
to the
Attorney
full
Anthony,
video,
you
hit me
finish playing.
with it in locals
Thank you,
chat or
sir.
something,
Did
please.
you see during the playing of that video, the image that was captured as a screenshot and presented to you in your direct testimony as
Oh, my face hurts from laughing.
175?
Objection leading.
Overruled foundational, the witness may answer.
Yes, I
A lot of.
You were questioned on cross-examination as to your ability to identify Mr. Brooks in Exhibit 175, correct?
Objection. That question was asked initially by Attorney Copper.
Overruled. The
Yeah.
witness may answer. Sorry.
Yes, I was.
As you just watched the entire video again now in court,
Got it now.
as states Exhibit
Thank
178,
you,
did
locals.
you clearly see Mr. Brooks in that video, sir?
Objection leading.
Overruled. The witness may answer.
I believe there's no doubt that that's Mr. Brooks in the video and later standing next to the Ford Escape.
Thank you. I don't have any other questions, Your Honor.
As to this particular piece of evidence only, Mr. Brooks, you may ask questions of.
Oh, we're gonna have recross.
no.
That name. Yeah.
Noted. Do you have any questions?
Judge, why would you do that?
When did this video?
This is how she's
when was
she's
this
doing
made?
this
It's new.
for
Because
the
I don't have it.
objections
It's definitely new.
Correction, that's not a question.
to
for the witness,
recognize
Your
his
Honor.
problem
That
with
was a
new
question,
evidence.
question.
Sustained.
was this
As to the
video
form
made
of the
exhibit?
question,
When was this video made an exhibit? That is a question.
I object to the question directed at the witness, Your Honor. It's beyond the scope of his knowledge.
Oh,
Well, he said he saw it.
call the DA as a
but that's
witness
not the
now.
question is. So you can rephrase
No.
your question if you want
When
to,
did you see this exhibit? When did you see it?
with the understanding that you're asking, when did he see the video? I will
When
allow
did
the
you see
question
this
to be
exhibit?
asked. With that understanding, you may answer, Detective Casey.
Am I answering when I saw the video for the first time?
Yes.
Objection, Your Honor. Why is something always funny at that table?
I-
It would be the same thing. I'll take that as disrespect because they were allowed to say something and I said under my breath that was disrespect.
I
They
would
just
direct
did the
both
same
parties
thing.
to avoid commentary.
Okay, well, can
and
you do that,
gestures
please,
and
and
faces.
admonish them?
Yes,
Because
I
I'm
will.
always the one
Absolutely.
getting admonished.
Everyone.
I take that as disrespect too.
Sir, can I do my job? States directed to avoid laughing commentary. I didn't see it, so I can't further comment. I was looking at
All these
the
cameras in
witness.
here, don't nobody
However,
see nothing.
Well, the judge isn't looking at the
I'm advising
cameras.
both parties. to show
Come on,
I
man.
take that
decorum,
as a sign of disrespect. That brings me back to 40-year-old virgin. Using these big words, I don't understand what they mean, but I would take it as a sign of disrespect.
attention, and to let them do their job by focusing on the testimony and exhibits and evidence that's presented. Go ahead, Detective Casey. You can
100%
answer
chance it was the
question
younger
about
male
when you
DA
have
that
seen
was
this video
laughing or
prior.
saying something under his breath.
I saw the video within a few days of Mr. Brooks being arrested. I've reviewed it since then a few times. I reviewed it yesterday and again this morning, and now in court again.
You said you reviewed it yesterday and this morning. If you had seen this video numerous times.
This is
before
interesting
yesterday
because
and
this
today,
is why he was
you
recalled,
need to
it feels
do
like, is
yesterday
this
and
video.
today.
Objection, argumentative.
Grounds.
Sustained
This is interesting.
form of the question.
Why did you need to review it this morning?
Objection, argumentative.
Overruled, the witness may answer.
Because I wanted to be 100% sure of the content, and if there's any questions that were asked of it, I wanted to make sure that I would be able to answer them appropriately.
And why was this, to your knowledge, why was this video never brought up in your earlier testimony?
Objection, that's a
Grounds.
misstatement, Your Honor.
Because I wasn't asked about it.
It's
The
not
form
brought
of
up
the
in
question
the
assumes
testimony.
facts not in evidence.
If you have seen it numerous times before today, why did you need to
I think that's a good
make
question.
sure if any questions were
Say
asked,
what you want. I think that's a good
or
question.
however you refer to it?
Well, the
They brought
answer is
you
I wasn't
back
asked about it.
But he wouldn't have knowledge of why it wasn't brought
Yeah.
up.
That's fine.
Trial
So you can
strategy
still
isn't
hear the
his.
question.
This morning,
They
No,
brought
this
you
is
back.
something that you had viewed
This is a
numerous
good line
times
because
before.
the question is, are you
I'll see what
Objection.
they
Full
colluding
objection.
with the prosecution
Compound.
to bring in
Asked and
evidence that
answered.
was brought against me
Misstatement of
as a
the facts.
surprise?
Argumentative.
Sustained.
But he should ask for the jury to be removed from the room and make a legal
Did you view
argument
the
about
video
this
this morning
evidence in
because
general.
you knew
That's why you need
And then
a
move
lawyer.
for a mistrial.
that the
That's why you
video
need a
would be
lawyer.
made an exhibit this
I
morning?
would just go with the Lucille Bluth Arrested Development
That's
defense.
not-
I don't understand the question and I won't respond to it.
This is mind-boggling. This is
Mind-boggling.
Oh my God.
Yeah, again, so if this trial were conducted with an attorney and this
Can
surprise
you clarify
evidence
again
was
why you
dropped
viewed
and
the
that's
video this
true,
morning?
I mean, this is
Objection
where
has
you would
answered.
actually ask for a sidebar.
So you're gonna
You
sustain
would potentially
everything?
move for a
It was
mistrial.
already answered, sir.
So this is surprise
Next
evidence.
question.
Haven't had time to
And
review
I'm
it.
asking for
Should be
It
clarification.
never
sufficient.
comes in. If a lawyer's on this case, this evidence
Next
never comes
question,
in. It
please.
is way
I'm-
too
I'm-
prejudicial for what it proves. That picture, maybe.
This is
And that's why they did it that way
You may
at first.
step down now.
There's 0% chance
people
this,
is trying
this
to do
video
is not fair.
I actually had a
I think
civil trial. They tried to put in
Don't
my
tell them
client
all
like
the
rapping.
information
Mr.
you
Brooks, I'm
need
going
to
to take up all of your
And it didn't come
objections
in.
outside the presence of the jury. I'd ask that you honor my decision to do that and you show courtesy and decorum.
Because you asked.
Mr. Brooks, please.
Because you asked. That's all.
Always pushes it
Just
one more.
asked.
Always.
I see what you people are trying to do. It's not right. It's not fair and it's not right.
Dude, I can't hate on him for this part because he's got nothing to lose.
You can have a seat once the jury's outside.
You're
of-
absolutely right.
of The objections previously.
Not going to hold him in contempt. The worst thing is he's going to get grounded to the other
First
room.
of all, Attorney Opera, if you can make a record as to this exhibit and whether it's been turned over previously.
There is a lot to be said. If you're going to go down in a blaze of glory.
That was sent initially to the public defender's office, and now we have a record that those 3 boxes were turned over to Mr. Brooks.
Objection, I don't consent to being called that name, and it was not in the video footage that I have obtained. That video was not part of it. Do you think I would sit here and be this irritated?
Mr.
by
Brooks, I need
something
to
that
make
I
a
saw?
record. So
Yes, I do.
Please sit down.
I think
There's
you'd
no
be
need to
irritated
stand
regardless.
At the moment,
I feel like standing right now.
please sit down.
I feel like standing.
She has to win this battle.
Yeah,
She
order
has
him to
force
sit
him
down.
to
Based
sit.
on the offer of proof
I
provided.
can't believe
by
she
the
does
state,
that.
And it was provided
empty-
to prior
empty threat.
counsel. That satisfies me as to that issue.
That's
I
inaccurate.
indicated I
That's
would-
inaccurate, Your Honor. Can we have the prior counsel testify to that then? Because
Not at this time,
I
sir.
have not obtained that. Right now, that was my first time seeing that as an exhibit. That's
Mr.
why I
Brooks, I
raised the
presume, and you can correct me if I'm wrong, but you're familiar with that video? Yes or no?
What
shit.
does that have to do with what we're talking
Because
about?
I'm going to make a finding based upon what I viewed in that video, that there is absolutely no surprise to you. It appears to me, even without the video, that that's a music video, that you are in it, that the vehicle that has been the subject of this entire case, that red Ford Escape with the plate that's been testified to, is in that video. That video is relevant for a number of different reasons. The first of which, it goes to identification of you, identification of the vehicle. You opened up the door.
Yep. I mean,
through
that's
your
the real reason
cross-exam
this
of
came in.
Detective
Yeah.
Casey about his ability to identify you in that video. And when I say identification of you, specifically as it relates to Detective Casey's opinion that that's you in the video, of course, it's ultimately up to the jury to determine that.
Okay, there she goes.
And what
I was
relevant.
thinking she was getting a little bit too hard on the editorializing there.
The door for the state to show that video, because you directly attack the credibility of Detective Casey through his knowledge of it and the identification by him of you in it, because the still image was of your back.
Okay.
So that opened up the door, and it's proper. There's absolutely no surprise to you that that video exists, and that is my finding as it
What do
relates
you
to
mean by
that.
it's no surprise to me that it exists? That was not the issue. The issue was, how was it made an exhibit at the last moment? How does it be made an exhibit out of the blue? That was the issue. The issue
State can
didn't
make an
have
offer of
anything to
proof
do
on
with.
that, because obviously they marked it as an exhibit.
But with all
So
respect,
go
Your
ahead,
Honor, you're
Attorney Opera.
mischaracterizing what I said, and the record needs to be clear. The issue that I raised
Record's
was,
clear,
how
buddy.
does this at the last minute, out of the blue, become an exhibit. That was the
Go
issue.
ahead and make your offer of proof on that.
Thank you, Judge. And another thing worth noting is the testimony of Detective Casey that this video was obtained from the defendant's own Facebook account as well. The court is well
Objection,
aware.
he said social
There's
media. He
nothing
didn't say
Hold
what it
on,
was.
sir. Stop interrupting. We have to make a record of it. You've
Then make
She's
the record
interrupted
clear.
multiple times. I've been abundantly
Make
patient
the record
with
clear.
you. Again, another interruption. So you need to be quiet
This
and let
motherfucker
the
is
state
not going
make
to
a
let
record.
me.
Stop
She's just
gesturing
asking
at
me to be
me.
quiet.
Stop rolling your eyes at
Are
me.
you?
Stop
I'm
mumbling.
looking right at you. I'm not rolling my eyes.
No, you
I'm
have
looking.
throughout. I've seen it
I'm
and
looking.
I've made note
I'm
of
looking
it.
at you. Okay, so are you asking me to be quiet or are you telling me to be quiet?
Go ahead, Attorney Opper.
Thank you, Your
I'm
Honor.
gonna take that
And
as
just
asking.
to indicate, Your Honor, this court has been abundantly patient with Mr. Brooks. He challenges the court's authority repeatedly. This court absolutely has the ability to tell him, sit down and be quiet. And you haven't done that. And I know why you haven't done
She's
that,
like,
Your Honor.
please do it though.
We appreciate that.
Please do it.
He is not in control of this courtroom. You are. And he needs to understand.
You shouldn't have to tell the judge that.
This
But I'm glad she
video
is.
was relevant based on his questioning.
Sure.
She's
Detective
telling the judge
Casey,
that in the
as you
right
just
way.
indicated,
Exactly.
challenging
We
his
appreciate that
ability
you're not
to
using your
identify
authority
the
the way you
person who
could,
had
but
their
you could.
back turned to the camera in the still shot of State's Exhibit 175. Trials are fluid. When he opened the door to that, we came up with the video which Detective Casey testified repeatedly on direct examination and cross-examination as to how he knew that was Mr. Brooks because he had seen the rest of the video. He would not accept that. He pushed it and pushed it and pushed it until we played the video. The lyrics of that video probably would have been prejudicial. Originally, I wasn't going to ask for volume. Then I did because he pushed it again, and his voice and his mannerism of speech, I thought would have assisted the jury in identifying Mr. Brooks as the person in the video with the red SUV.
I'll play the
However,
yard.
you smartly asked me to play it without the
Smartly.
audio,
Smartly.
and I did that, and then I never went back to that. This is all to the benefit of this defendant who continues to suggest and impugn the integrity of this court and this prosecution without basis. He doesn't like it because the evidence is stacking up and stacking up. And whenever it does, his response is to accuse you, the court, or the prosecutors of being unethical and hiding things. There is nothing in law that prevents me from pulling something out of my briefcase right now and making it an exhibit if it's relevant. You decide what's relevant, what's admissible, not Mr. Brooks. There is no law, he can cite to no law, no authority whatsoever that says I can't make an
She's
exhibit
pissed.
essentially
That mic is
on the
barely
fly
containing her
if
rage.
it's called for, and that's
I just had to
exactly
turn
what
my
just
volume
happened.
down.
So I apologize for my tone with the court. I don't mean to direct this at
She's
the
pretty
court.
awesome, though.
It is very frustrating.
Too bad
The
she's
court
not
has
the judge.
demonstrated much more patience than I have with Mr. Brooks because, again, I do not appreciate his impugning the integrity of these proceedings, of Your Honor's efforts to run a fair trial, and of our efforts to run a fair trial. We have ethical obligations as well to be fair in this courtroom. We have respected that entirely. The reason I was laughing 30 seconds ago was
Oh, it's
because
her.
the exhibit was mislabeled. There was an extra Y and it said Exhibit E, EXHIBITY. And I turned around to the paralegal and pointed that out, and we laughed over it, the word exhibity. That was it. There has been no disrespect directed at Mr. Brooks directly in any fashion.
Nice.
So he can object all he wants, and he has made that clear. He will continue to object and obstruct the court and obstruct these proceedings every last chance he gets. But legally, everything has been above board and proper, and this exhibit is no exception.
Nice.
I apologize for my tone, Judge.
Jesus, I feel like I did something wrong.
Record
Come on.
made.
I object to that.
my previous ruling doesn't change in any way that the exhibit is relevant. I indicated I would take it up because, and I'm taking what the state's saying as withdrawing the request to play the lyrics.
That is correct.
All right. I have not heard them, but I'll certainly take the state at its word as an officer of the court that it would be prejudicial based upon the lyrics that are in that video, but my decision to admit the video without audio stands. I do want to take up two other issues. There was an objection to questions regarding cross-examination. So the objections were by the state. One had to
I'll be
do
right
with
back,
possible.
guys. Just a second.
There was questioning about possible testimony with his niece and nephew, and then the jail cell search issues. So, Mr. Brooks, you asked.
Hey, everybody, go and subscribe to Lawyer You Know,
objected,
and subscribe to me too.
Component of what would presumably come in through the testimony.
Like everything we've ever done.
Detective Casey, what is your offer of proof as to why I should allow Detective Casey to come back on the stand and testify about his interaction? I believe it was with your mom and possible testimony of your niece and nephew.
It don't matter with Detective Casey. He's off the stand. He's not going back on the stand.
No, but I told you I would recall him. I wanted to take it up outside the presence of the jury.
How do I supposed to know?
So are you withdrawing that, sir?
How am I supposed to know? I think I deserve a chance to rebut what was just said. I think I deserve that much.
Not really how it works.
Trial.
You don't deserve much of anything,
What
homie.
information do you want to provide to me about that last exhibit?
About what last exhibit? I'm talking about the audacity of the prosecution to just put that on the record when it's stating it's untrue.
I don't know what you're talking about. What's untrue?
We just heard her talk for 5-10 minutes straight. Now don't nobody know what I'm talking about.
That's been the whole time.
Specifically what you're talking
There's a
about,
reference
sir.
made to what I'm supposed to know about the evidence stacking up and this and that, as if that has any bearing on what I still think and what I'm still going to present. It doesn't.
Well, that's not what we're talking about at the moment. I made a ruling on an
She's been
exhibit.
laughing and making comments under her breath the whole time during the whole trial, and I never said nothing. I don't know what's being said, but I can tell that it's directed towards me. I'm not an idiot.
I haven't made any of those observations.
Objection, assuming facts, not in evidence.
No. What I've observed is
listen, please.
Go ahead.
For her to sit there and try to play it off as if she's not referencing to me, she must think I'm an idiot. That is very disrespectful to me.
I got pissed so bad. There's no way I'm leaving this.
She's done it numerous times.
What are you talking about? I don't know what you're
laughing under her breath. Her trying to cover up the microphone so they can laugh and hee and key. That they've been doing that the whole time.
I'm gonna start
I didn't say anything about it.
I have not noticed that. What I notice are three attorneys who cover up the microphone so that they're not heard when they're conferring with each other about evidentiary issues or about testimony.
So why is it always laughing and giggling?
I haven't noticed that other than the one thing you pointed out.
Well, we have cameras. That's what the cameras are for.
Let's refocus our attention on what we're here for, and that's
okay.
this
Then
trial.
I take that.
If you have anything you want to put on the record,
I'm putting it on the record.
As
if I get a
no,
chance.
you need to let me finish. As it relates to the video and my decision to admit
She just admitted that she just now came with the exhibit. It was not that she just said. I just made it with the exhibit too. It's not an exhibit before she made it one.
So do you have some legal basis, sir, for your position? Because I'm not.
What do I need legal basis for when she just admitted on the record that she just made this exhibit up?
No,
right
she
now.
did. That is a complete mischaracterization. Sure, she did not.
That's what. So she wasn't implying that by saying that she can pull anything out of her suitcase.
So that's a figure of speech.
Okay, so what is it implying to? What would that be implying to?
How would anyone in my position? Because you're not providing me with any legal basis.
I didn't even finish. You told me that I can make the record. I'm attempting to make the record.
Sir, as it relates to the video and my decision to admit it.
I just said that you didn't even let me finish.
You're not letting me finish.
You didn't let me finish either, Your Honor.
Because you're not providing me.
But how do you know I wouldn't get to that if I didn't finish?
You're not providing me with anything basis for which I would consider changing my mind. So the state's withdrawn their request to play the audio.
Then why play the video at all then?
I've already made a ruling on that. You're questioning the ruling. You're not asking me to reconsider it based on any legal basis.
There should be a legal reconsideration of it.
Then you need to provide me with the legal basis for that, sir.
So I'm supposed to just come off that with off the top of my head?
Yes.
That's ridiculous.
You're representing yourself. It's not ridiculous.
It is ridiculous. So I was supposed to already come in here this morning and say, a video is going to be shown off the fly at the drop of a hat. Let me try to find some legal thing to combat. How am I supposed to do that?
You open the bottom line is you open the door to the playing of that video.
We're not talking about
and the video was
doors.
previously provided to you during
We're
discovery.
not talking about opening those doors. We're talking about being fair.
There's absolutely
Because if
no
I would have did
prejudice
that,
to
Your
you.
Honor,
In
with all
terms
due
of
respect,
This is why I was $120,000 in debt at 25 years of age.
if I hadn't done that, it would have been a big
I'm
thing.
advising you.
Are you
that
asking
you
me?
need. I'm advising you, sir.
Oh, okay.
I'm advising you to sit down and be quiet.
Means.
And if you interrupt me again, you are on notice that you will forfeit your right to be present
So
in
you're
this
holding me
trial.
in contempt.
Do it.
For the entire trial?
Send him. Do
Did
it.
you say the entire trial?
I never said any such
You said for the trial. So what do
Please.
you mean? I'm asking, what do you
Mr.
mean?
Brooks, you continue to
That is
come
not,
at me.
I don't consent to being called
You
that name.
continue to fight with me.
I'm
You
not
are
fighting
being
with you.
disrespectful.
I'm not fighting with you. I'm not.
I'm
But
going to give
you
you
said I
one
would have
last
the chance to make the
opportunity to
record.
sit down and
Judge
be
is about
quiet
to
so I
bring
can
out
make
that
a finding
Are
as
you
it
asking
relates
me
to
to
other
do
West
that?
things.
racism if you
Asking.
don't
I
want
don't need
to.
to ask, I'm telling you.
Oh, finally. Finally, she's telling you.
Thank you.
Show him what those
Two other issues.
those
that came up
taser
that I
shackles are all
promised
about.
to take up outside the presence of the jury and give, if appropriate, Mr. Brooks the opportunity to ask further questions of Detective Casey. There was questioning by Mr. Brooks about possible testimony and why it had to do with it was in the context of him questioning Detective Casey about
Come on, Brooks, you cuck. Don't let a woman tell you what to do.
and about a time in August,
Stand up to her.
and there was some reference to his niece and nephew. And I sustained the objection. I wanted to take it up outside the presence of the jury. That's the first issue. The second issue was the questioning of Detective Casey by Mr. Brooks related to the jail search. Do you want the opportunity to question Detective Casey about either one of these two topics is my first question.
Okay, why was it an issue with me bringing this?
Mr. Brooks, I'm only going to ask you one more time, and if you
I'm
don't
saying
answer
if I don't
correctly,
understand,
then
if I don't understand what was the problem in the get-go with the question, how am I supposed to answer it now?
Mr. Brooks, listen to me, please. I'm going to ask this question one more time.
Man,
It calls for
I
a
don't
yes or
like
no.
your
Man
tone
with
and the way
nothing
you're
to
talking
lose.
to me. I don't.
Mr.
I don't
Brooks,
She
appreciate it.
doesn't like her tone.
Sit down. I don't care if you don't like my
I'm not
tone.
gonna-
You've
I'm
been
not gonna
pushing
sit
my
down.
buttons all day throughout this entire
Okay, you've been
trial, and
pushing
I
my
have
buttons
shown
too.
the utmost of respect
No,
for
you
you,
haven't.
and I don't
Absolutely
appreciate
not.
you impugning the integrity of this court.
If that's
I
what you
don't.
want to call it, that's fine, but it's not
Stop
Am I
accurate.
the only one with an erection at this point?
Please stop talking.
I need to make a ruling.
Yes.
And
Well,
I'm
let's-
purposely
let's
not
talk-
putting
let's
you in
talk
the
to
other
you later.
courtroom
Let's
right
talk to each
now.
other like adults then.
Mr.
Because
Brooks,
I've never told you to stop talking.
You can't. It's a
I'm going to ask the
You're
question
not
one
the
more time.
judge,
If he doesn't
dude.
answer it, I'll take it as a no. Do you want the opportunity to question Detective Casey regarding either his questioning or meeting up with your mom and your niece and nephew about possible
For
testimony?
historical
with your
reference,
mom?
for someone who does not have anything to lose and does something like this, go back and watch tapes of the Charles Manson trial. It was just like this, but
What was
in a
the
lesser
problem with
degree.
Asking the
All
question
right,
about
he's
the
not
jail
answered
cell.
my question. We'll move on.
I'm trying to understand. If I
All right,
don't
we're gonna take a
understand,
break.
how do
We're
I know?
recess, 15 minutes
How do
from
I
now.
know
Thank you,
what I'm
everyone.
supposed to answer if I don't understand?
There we go.
And I don't agree to a stop.
She had to call the break. She's letting him win these things. Like, I mean, she dressed him down a little bit, but at the end she had to take a break because she's losing her cool.
Why doesn't she send him out? Like, you've already done it. Send him out. He knows you're not gonna. He's baiting.
Just
you,
exert your
literally.
authority.
So I said this, but the court was really loud. So, but it's
Was it?
there is a little bit of an advantage to being someone with nothing to lose. She can't punish him. The only thing she can do is remove him from the courtroom, that's it. He's like, "You're going to hold me in contempt?" She can't, like, she can hold him in contempt, but he's already being held. There's nothing there. If she holds him in contempt and removes him from the proceedings, she'll likely have to adjourn them for the day because he has the right of confrontation. So the best she can do is put him outside of I mean, technically, I guess there is that 70s case where you could just remove him and let the prosecution go and him
But you don't need
unrepresented.
to. Just put him in the other room and mute him. And like Jeff said, with holding in contempt, the reason we wouldn't want to get held in contempt is because we'd get thrown in jail. He doesn't care about that. He wants the delay. He wants her to have to make factual findings. Why did she hold him in contempt? What is his punishment? Is she going to fine him like he cares about that? He just wants to delay the trial. So I'd put him in the other courtroom, mute him. He was there for the entire state's case in chief to confront all the witnesses against him. They're done. They're done. Confrontation's
Give
done.
him a stupid objection sign.
Exactly.
Yes, that's true. Very good point. The state is done now. We're on recross, and that recross has been interrupted. She can easily say he's waived his ability to conduct that recross, which he didn't have a right to anyway. So yeah, she could shut that down at any point, and just end this. The state could rest, and then they could go to lunch. They're going to come back after 15 minutes and then have what? I guess maybe they'll get his opening statement in, maybe before, and then go to lunch. We'll have to see.
Well, like I was saying, this isn't unprecedented. This is what happened, back in the day with Charles Manson trial. It was all these interruptions, all of this bullshit going on because he could, and he literally had nothing to lose. You just got to let it play through.
Yeah. Well, actually, I mean, yes, but what Peter was saying and what's been shown in this trial, although it's kind of a test case, so we'll see, but I think it's probably appropriate, is she doesn't have to let it play out, because in the Manson trial, there wasn't another courtroom with a live video feed where this could be done. In this trial, there is. They could just move him over there, and he's fully present for all the proceedings. They can just control his disruptive nature for judicial economy and for the judicial purpose of controlling the courtroom and conducting an orderly trial. One that is, by the way, controlling these outbursts is to his benefit. That's why she removes the jury.
Yeah.
These outbursts would be extremely prejudicial negatively towards him. And that may be some sort of stupid attempt that he's trying to make, but the judge has the ability to control it. And she's doing
right now.
a little bit. Yeah. This is
like
enough.
mom. This is playing mom off dad. This is like if you don't do this, I'm going to spank you. I'm going to give it to the count of 3. 1, 2, 2.5.
All right.
2
This is your
3/4.
last chance. All right. Now this is your last chance.
Yeah.
And then as soon as she sends him over, she says, whenever you want to come back, just let us know. Say the magic words and you can come back.
Yeah. He's been absolutely improper today. A lot of the days he's been okay. He has little outbursts and here and there, and that's fine. Someone in the locals chat asked, since he's saying he doesn't understand, doesn't that mean he needs to be represented and that he's not competent? No. One, Brooks has demonstrated over and over that he does understand what's happening in the courtroom. His questions, his arguments, they're responsive to what's going on around him. He is aware, and that is effectively competence. Being good at representing yourself, it doesn't factor into the equation. And
It's
him
not
saying,
even just being good, Nick. It's in the colloquy. You will not understand certain parts of this process. That's why we provide a lawyer for you, sir. Are you waiving that right? Exactly what you're saying. That's not that's not how competence works.
Yeah. And he's present, he's aware, he's in his questions are intelligible. They're related to the subject matter. In some cases, he's actually had some really good lines of questioning that a defense attorney would ask in the same way. Today, we had some examples of that with this same witness. And so, yeah, he's got the legal competency nailed down. Now, this judge could, I think, maybe revoke that and appoint a public defender at this point. I think she has the grounds to do it, but she also has the grounds to not do it. And they're being abundantly cautious with this one because they don't want any opportunity to say that his constitutional rights were infringed to his detriment or to his prejudice. And if they mess with his voluntary waiver of his Sixth Amendment right, he could argue that he was prejudiced by being forced into representation that he didn't want. with people who did not want to accept his trial strategy, et cetera, et cetera, et cetera. So she's doing it right. She just needs to be a little bit more forceful on this. And the
We just got to drop
prosecution
the
let her
hammer
know.
at some point. Yeah.
She finally said, I'm not asking, I'm telling you to
I
sit
think she
down.
said, I'm
something.
telling you,
Yeah.
sit down
Yeah.
and be quiet. Yeah, she just has to basically follow through on what she says. That's how
Yes.
it works. And that's how it's appropriate and not a reversible error when you say, Mr. Brooks, you've interrupted me again. If you do it one more time, you will be in the other courtroom. And as soon as he interrupts you, just send him to the other courtroom. That on paper, and even in color, since we get to watch it, that looks like you did everything appropriately and you followed all the rules as a judge. She is going above and beyond anything she needs to do, which I understand. And frankly, that's probably the best way to handle it so he doesn't get what he wants and to do this all over again. But I mean, at this point, yesterday, I think he went off a little too much too, Nick. And I think it's because they're kind of coming to the end of the state's case and he may see now the only way I can delay is for me to just keep calling witnesses and making arguments, because what he was saying, nobody's going to tell me what to do. Nobody's going to tell me to stop talking. I'm a father of grown children. It's like, go to the other courtroom. Go ahead.
Yeah.
Go scream that to the wall in the other courtroom. You know that, I mean, that's, nobody would fault the judge for doing that.
Right. And I think she really needs to avoid statements like, you've been pushing my buttons all day.
Agreed.
Stuff like that. She should not.
Yeah.
The judges are supposed to be in control of themselves in their courtroom. They're the model for the decorum. And you can talk to lawyers, and anytime they have a story about a judge losing their mind, you know, lawyers tend to find it kind of funny because it's like, you're not supposed to be this person. You're supposed to be neutral, aloof, impartial, and to ultimately be the god of the courtroom. And God shouldn't lose his temper.
He shouldn't make decisions because his buttons are being pushed. People are asking in the chat what I mean by on paper. Appellate courts
Unbreaded.
Appellate courts read the transcript. They read the record. So in black and white, they don't hear tone. So in black and white, if she says, interrupt me one more time, and then the stenographer has him interrupting her, and then she kicks him out of the courtroom, on paper, she hit all the check boxes and could kick him into the other courtroom. That's what I meant by on paper.
Wait, was it just on paper ?
Literally. Oh, is that one of your things?
Yeah.
Sorry. Okay.
Yeah.
No,
all right. I was trying to answer. Okay. All right. That's why you guys are making fun of me. Okay. Now, you making fun of me, Riz? You making fun of me, Riz?
Not making fun of you. I'm not making fun of you.
No, that's cool.
No,
You had to bring it up.
You got me. You got me.
It's only like, it's a minute. Here we go.
It's a good minute, it sounds like.
So this guy is a hero of the channel. I wish Darrell Brooks would read from his book and bring it up in court.
But I'm so disappointed you missed the day that Matthew Harris testified in this case.
Yeah, that was too bad. Here we go.
Touchdown. Paper? Unbreaded. Nope. Touchdown. On paper? Unbreaded. Right. Touchdown. On paper? Unbreaded. Touchdown. Paper? Unbreaded. Right. Touchdown. Paper? I never gave a shit. This was never to these. Touchdown. Paper? Unbreaded. Die.
So that is great. I mean, that's what I get for looking at the chat. I look over at the chat for 1 second. That's what I get. I learned lessons today. You know, I learned lessons.
Oh shit, hold on. Here we go. We've got the Math Boy Fly video. I did promise it. Should we play it?
I've been saying this. Oh, it's something. It's made for Rumble.
Wait, no, Chris Farley's not part of that video.
Wait, what the hell is it? Oh.
Okay, there we go.
Turn it down a little bit. A little hot.
D-Mark got that heat.
Hit that bass synth.
I just got a load worth about a half a ticket. 30 in the blicker when I'm out here chasing chicken. Was observant to the game when I used to play the benches. Now I swipe the Vinci, got them looking at me different. I can't miss them yet.
Oh,
They
this
all
is
with the
overlaid
stitching,
with
yeah.
the footage.
When I kiss them, yeah. Kidnap you and miss it, yeah.
No.
Get your damn money
They
by
edited the
ceiling
damn
fan.
video.
Shorty wanna
Ah,
take a
no, this
chance.
isn't
I'ma
it.
need a cash advance. Only fuck with real
Wow.
gritters, and I've been around gorillas ever since.
We already
a
saw the
little
video.
nigga.
Let's just hear
Fucking
the
on my
audio.
babysitter. Put some prices on the nigga. You know they gon' come and get you. You see how the models did him. Now he look like Tyson hit him. I was in the slums any weather. I was still trapping, sliding on the pussy early morning. Bitch, you still lacking. More, I had to tuck it in my heel figure. You know I got still with him. Fully not that little pistol.
How's this
Hurt
man
they with
only have
cameras
3
on the
kids?
lights. Bitch, we still dealing. Give a fuck about the past, nigga. I'ma still kill you. No love for the suckers. Listen, get up in the field. We blitz them, shoot out all the ammunition. They move like some caterpillars. Post this on your social feed. Addies that extend release. Too simple, your talk is cheap. I won't stop till you deceased. Coming out your face, you bleed. Carbons, we gon' sweep the scene. Senses, we gon' find the heat. Take you out the movie screen. Shout out to my shooter team. They gon' handle teams for the revenue. Can't even eat off these dishes. They got residue. Remember when I used to play the hard back in middle school? Remember when them cases had me stuck
What are
in
you
that
writing?
cubicle? I'm playing like a stupid dog. You know what I do to you. Cool on the text, so you keep shooting when I shoot at you. The panoramic musical. Beat you like I'm Rugaroo. Call a Uber before you double back and hit the
This is
Uber.
the only rap song with Rougarou in the lyrics ever.
Bustin' plays, bumming through the line. Better watch my J's. Not a frame, shutty. These Cavalli, these ain't Cartier. Get the face, then I knock the shorty out of negligee. Blood hit me from
Knock the
seal,
shorty
told
out
me
the
50K.
negligee. I
Don't
like
wait
that.
for nothing, bitch. I'm running to the real estate. Stay away from suckers. I don't fuck with niggas anyway. Snitching niggas, hate niggas. Stay the fuck up out the way. Got another low. How we playing with them digits? Weighing up them bowls, selling coke around the digi. Playing with them bloods, they
This part's kind of rude.
Nigga, I'm a menace, and that's worth to Mr. Wilson.
Wait, why you got lean in there, man? What did that do to you? Secret squirrel. Okay, anyway, so that's the audio, ladies and
Wow.
gentlemen. We were asking for it. I didn't know about the overlay or the 2-tone of the video or whatever. Having the edit.
Wow, that was better than the U2 album they downloaded on the
Oh.
iPhone back in the day.
Oh my god. That was I wish they would have played it in court though. Like that would have just been because the jury would have been like, but it would have been way too prejudicial. I mean, way too prejudicial.
The judge saved him there. Yeah. Yeah. I think so, probably.
Maybe.
Okay, let me hit some of these chats. By the way, guys, both of my guests
Homies.
today, we've got The Lawyer You Know and Legal Vices have thriving and throbbing YouTube channels, and you should definitely check them out. Make sure you check out their content. Peter's been covering this case not live, but you've been doing really good, succinct recaps of what's been going on, and he produces excellent content. You guys should definitely check that out if you're still on YouTube.
I just shit
Some of
talk.
some of us have had issues with that recently.
Yeah.
Okay, Soundwave TM says Rekieta Law also, here's some more drinking money as well. Oh, that came in after this one. Hey Nick, here's some change for your informational class in law. When you are online, I always make sure to watch to help with my journey into technology law. Oh, good luck, brother. That's a good area to get into because tech is only growing and tech law is always changing. So there's tons of opportunity there. Ericon says, Brooks, F. Lee Bailey, you are not. Rude. I think he's doing fantastic. He's probably going to win. XGS Wood says, Nick got some blue rye on the way. Lucky. Unrelaxed, would you consider this prejudicial to the defendant who shall not be named? Evie says, gotta love it when you have one viewer and this chat, this is what you got to deal with in the chat. Ugh. And it's, oh my God, it's all the same person. Have fun with that. Okay, let me read some of these over on Rumble. Torch Medic, thank God I was scared when I didn't see any of you guys streaming it. I was scared I would have to go to Law and Cuck's channel. Well, someone's been streaming this every day, even if I happen to oversleep sometimes. JP Drennan is on the record, the new on paper. You know what is oh shit, Odyssey just went down. It'll be back.
Oh.
Anyway, that's one of the most aggravating things for me I don't know about you guys, but when he keeps saying it needs to be proven on the record, like he just doesn't seem to like understand. Well, he obviously doesn't seem to understand that. First of all, you don't prove something on the record as far as like subject matter jurisdiction. The judge just issues an order or a ruling related to the objection or the motion, and that's it. That is on the record, but he's never going to let go of subject matter jurisdiction because that concept is just not present for him. I guess. I don't know. Maybe that's what it is. Maybe I'm crazy. Does that bother you guys?
There's so many things that he does over and over again that are bothersome. I mean, I just want to make sure that's noted for the record, and he won't get off it until the judge says, okay, it's noted, as opposed to just explaining everything you say is on the record because somebody's typing it down on paper. And I just, it's going to come out a lot now. And I mean, the plaintiff stuff to me is so annoying every time he asks about the plaintiff, but I got to be honest. I can't remember a criminal case where I heard a judge call the state the plaintiff, because I don't think that's actually right. I don't think they are considered the plaintiff in the case. So, but she said it. If you listen to some of the pretrial hearings, and she's even said it in the trial, she has said that they are the plaintiff, and that opens the door to this craziness, as opposed to that's a civil case, sir. This is a criminal case.
Yeah. Yeah. She should. I didn't know she had ever said the words, the plaintiff. They should that just does not exist in criminal law. That's not the thing. The complainant is the state. That's who it is. They're
the charging party because they represent the people of the state of Wisconsin. I mean, that's the point.
Exactly.
They represent the interest, the public interest and safety of the residents of their state. That makes total sense in the criminal world. So all these questions, that annoys me more than anything in this trial.
Team Ruby, Brooks reminds me of my ex-husband. 4 ex-wives after me, but it's not him. FFS, can we just beat him with a dead armadillo until he can't sit, stand, or speak? You know, that would be the one thing, just declare a mistrial, but release him into a room with the victims' families.
It's Wisconsin. Just sick Taylor business on him.
That's true. Here. Meet with this fine, lovely lady. Also, here's a bunch of meth. See how this works out for you. VT Wayfaring Man says, in trials, I see testifying detectives at the prosecution for the entire trial. How are they allowed to do this when other witnesses are barred from attending? They're allowed to. I actually disagree with it. I don't think it's proper at all. I don't have a good answer as for why the detectives are there in the Rittenhouse trial. I mean, the detectives who would testify were like handling evidence and stuff like that. It was really strange to me that's allowed, but it is allowed. It shouldn't be, in my opinion.
Usually the lead investigator is doing most of that.
Right. I just wish they wouldn't. I think it's really prejudicial to have a lead investigator sitting at the table with the prosecution when the lead investigator will then testify. But I guess the lead investigator is at that time a representative of the state. And so in a normal adversarial proceeding,
like
that wouldn't be right. That wouldn't be weird at all.
Right.
Mr. Squiggle says, please excuse Jeff. He's been having issues with his toaster all morning. Genkin, I return for value what I accept for value. Just Gen T, I appreciate all the different lawyers' points of view, so invite who you want. We learn. Well, I love all of them too. Thank you. B Bob.
That's like Brooks telling the judge that, listen, Nick, I'm not going to tell you who to invite, so you don't tell me who to invite to your stream. Okay.
I love that. I've never told you to be quiet. It's
yeah.
Like,
you're right.
Yeah. It's a good move. If I told a judge to be quiet, it would be really bad. Really bad, actually. What was that? Was that you?
That was me.
What was that?
My phone just started playing songs.
What song was that?
It was on a Instagram story.
Oh, okay.
The record in State versus Brooks appearances are as they were before.
I think the audio needs to turn on.
Yeah, let's do that. All right, let me do that again. We have back on the record.
Stuff here.
State versus Brooks appearances are as they were before.
I don't consent to being called that name for the record.
That's like the least annoying thing he does to me now.
issues related to exhibits or other things before I bring the jury back out for what I believe will be the state resting?
Yes.
Your Honor, I do believe that I did check with your clerk. Everything that we have offered and admitted matches what the court has. So I believe we are good on that.
I have one question about Exhibit 89, and I don't know if I missed in my notes.
Okay.
What do the parties' notes reflect on whether that was received?
I showed that it was offered and admitted before it's published, or it wasn't published to the jury. But if not, we would move Exhibit 89 into evidence.
And do you recall what Exhibit 89 is?
It's a certified bail form.
No, I'm asking.
Oh.
I'm asking Mr. Brooks.
Oh,
So,
sorry.
that was the second of the 2 bail bonds. Do you have a recollection of whether it was received?
I don't.
All right, then what
I
was?
know I objected to it.
I know you objected when it was, I think, displayed for the witness who then testified about it. I'll receive it and also advise the jury. Were there any other exhibits? I have one other issue on evidence and exhibits as well, but are there going to be any other exhibits that we need to tidy up the record in front of the jury with?
I don't believe so. I know at one point, someone caught that we moved, it was either Exhibit 175 or 178 into evidence, and the court admitted either 165 or 168 on the record. So I don't know.
So maybe just had a misspeak.
Yeah.
You have any recollection of that, sir?
Recollection of what?
Related to what the state just put on the record. Do you know what witness that was?
That was Detective Casey.
Let me look at that.
Oh boy. Do I have 60 seconds, Judge? That's all I need to know.
175 was the screenshot taken from the video. I know I have a note that it was received and published.
This is why they don't do a full trial in Hollywood movies.
Just referenced it by the wrong name.
I thought it was 178. I thought you referenced it by the wrong number. So it's either 175.
I do have to take off at 1 o'clock my time, so about 10 minutes, just as an FYI. In case
165
something
or
cool is happening, I
178
just
was
disappeared.
referenced as 168.
What is 170?
And a reminder to the chat, I have to go in about an hour and 10 minutes as well. And I'll be doing a
I know
warm
that
invite for the
175
chat
is
to go
what I just said.
Correct.
either uncivil
What
law
was
or potentially
170?
criminal who are streaming this as well.
178 was the video.
Oh, that was the
video.
most recent one. Okay.
What did I miss? What did I miss?
Literally nothing.
What's the
They're
request then
deciding
as
when they're
it is
gonna
when the
start.
jury comes back in?
Your Honor, I just.
And what time are you out of here, Nick?
And a
There's
little
two
over an
different ways
hour.
to do this. I can put on the record.
I can pick it up after that.
Exhibit numbers,
all right.
and I can just put on the
I'll send
record
people
just to
there then.
verify that
That's
these
weird. He
exhibits
just
are
encouraged
all
everybody to go
offered
elsewhere.
admitted
So,
into evidence.
yeah, that's going to be
Oh, well.
awkward.
Reports.
Not for me.
They'll all forget in an hour like goldfish.
Yeah.
Records are the same as my
I know I will.
records. Or we can clarify just.
It's like 1 p.m. Central.
About exhibits 175 and 178 that were shown to the jury this morning. Those 175 and 178 were offered, and the court has admitted those into evidence. So however you want to.
All right, sir, do you have any position on how I address this in front of the jury?
Yeah, I'm rejecting
Undress it in front of the jury.
at all.
Well, those objections were already addressed. I'm talking about how I addressed to make sure the jury knows they were received by the court.
However you gonna do it is how you gonna do it. I don't think what I gotta say much matters.
Well, what you say matters, sir, but
No,
the
it don't.
fact that I've already ruled on the
Definitely.
admissibility is not something I'm going to revisit.
I what I got to say.
Hold on,
definitely.
that door is, all right, it's, sometimes that door upstairs malfunctions and, all right, I didn't hear the last part of what you said.
What I have to say about anything definitely doesn't matter.
I take
Fair enough.
huge objection with that, sir.
It's true.
And that may be your perception, but that is absolutely not true. This court takes your positions on evidence, legal arguments, admissibility, things of that nature. I take all of that quite seriously.
But somehow it's always overruled or discarded.
Sir, can I keep going because you've interrupted me once again? My perspective on all of this, sir, is when you disagree with a ruling, you interrupt, you try to debate the topic again and again, you make disparaging remarks either directly or under your breath that are audible. Sometimes you roll your eyes.
She waited for him to roll his eyes right there.
Just previous to the break,
I know
you
that
and
look.
I
I've done that
were
look.
talking over each other. I couldn't really get a word in edgewise. You wanted to debate topics that I've already made decisions on. I wanted to get clarification on whether you wanted to pursue any questioning, for example, with Detective Casey. I gave you multiple opportunities to answer questions directly. You chose not to do that. You directly challenged me about my authority in this courtroom. You refused to sit down repeatedly. Did I raise my voice? I absolutely did. Was I frustrated? I absolutely was. I'm sitting down. My voice is calm. I think the break was good. I hope for all it was good for me. We had had a very long morning. It was about 11:30 when we broke.
It was good for me. Was it good for you?
That's what it sounded like.
I didn't remove you to the other courtroom despite my repeated warnings because frankly, I knew I was going to take a break.
Jeff, I forgot to
I
fax
just
you.
wanted to get through some issues outside the presence of the jury, which is the proper procedure for how to address objections if the record can't be done in a way that when a more full record needs to be made is how I'll put it. And I indicated during the cross-examination of Detective Casey, I would take your objections under advisement. I would address them outside the presence of the jury. You chose not to answer my questions, and so I moved on. Now, with respect to, I want to also address exhibits and the normal course of exhibits coming in a trial. Because I think there's some misunderstanding and certainly confusion on your part, sir, about the exhibit list that I asked the state to file near the beginning. And that was frankly to assist the court and my clerk in keeping track. Most trials, the normal course of action is as long as an exhibit has been provided to a party previously, or in some circumstances, if not, it's rebuttal. We're not quite there yet. That as long as it's been turned over in discovery, oftentimes parties will simply have exhibits marked as they're presented.
I set up a stream for 1 p.m. Central.
There's not a legal requirement unless a judge orders it that would prohibit a party from marking a document that's been already exchanged and having it offered as an exhibit. There was nothing improper about what the state did with Exhibit 178. And I want to make that record very, very clear. As Attorney Opper stated, trials are fluid.
All right. I'm taking off. Check me out 8:30 tonight.
To what might be
Eastern time.
Evidence.
If you guys want to, check me out. Probably the wrong verbiage for this chat, but
this court made a number
thanks,
of
Nick.
trial rulings
Good to see you,
related
Jeff.
to acts
Yeah,
of
buddy,
evidence.
yeah.
Even during
have a
your
good one, Peter.
cross-examination today, you came awfully close. I had the witness turn to me and pause and say, I don't think I can answer that. in a clear recognition that that witness, Detective Casey, understood his obligation to honor the pretrial rulings. When we moved on from there, I bet that's happened a half a dozen times in this trial. And that's frankly to protect your rights, sir. The door could have been opened a long time ago to the other act's evidence with Erica Patterson. And I frankly kept it out, despite your questions. So with that, I want to bring the jury back out. I will ask the state. I'll simply just ask the state, are there any
Hey, what's up, Oz?
Morning.
anything additional the state's offering by way of testimony or exhibits? You can then address the exhibit issue. Then I'll ask the state if the state has any additional witnesses, and the state can officially rest. Given the time of day that it is, it's 11:58. I'm not going to have Mr. Brooks start with his opening statement. We'll do that when we come back after the lunch hour. I think, frankly, the time over the lunch hour will be good for everyone to regroup, hopefully get a little bit to eat, and come back fresh. And then we'll have his opening statement and the start of testimony. Before I bring the jury out, there's one other thing I want to do, though. I just need a moment to pull something up from on my computer.
Speaking of a moment, what you guys could do is take one moment to check out birchgold.com.
Is that addressing subject matter
Damn it,
jurisdiction
Darrell.
that you pulling up? When would that be proven for the record?
Sir, please don't interrupt me. I need to focus on what I'm
I'm not
doing.
interrupting you.
Don't interrupt Nick. He needs to grift.
I'm not going to be addressing that. So
So would it
don't
be proven
interrupt
on-
me right now. I'm trying to do something on my
Would it
computer.
be
I need to
proven on the
focus.
record?
Everyone watching should
You know
have
what
the
is
ability to mute
proven
him.
on the record is birchgoldgroup.com/knows. Birch Gold Group is interested in helping you protect your IRA or 401k with the ownership of
I feel it's
hard
important at
assets
this time
like
to at
gold
least
and
give you
silver.
the advisement.
Those durable
pursuant to
assets are
Special
resistant
Material 28
to market
is
volatility
regarding
and inflation.
your decision on whether to testify.
Judge, you're
I'm
pissing
not
me off
asking you
right
to
now.
make that decision,
I have a
but
legal
since we're
obligation
on
to do
the
this.
verge of you starting your case and it may impact your opening statement, I wanted to go through the following. Sir, are you aware that you have a constitutional right to testify?
I've been
this is good.
informed.
Here we go.
You
been
advise and
informed.
informed that you also have a constitutional right not to testify.
I'm not advised, I'm informed.
Are you advised and informed that the decision
It's
whether
more sovereign citizen bullshit.
Yes.
I don't understand the question.
are you advised and informed that the decision on whether you testify in this trial is for you and you alone to make?
I'm informed. Not advised.
He doesn't
are you
actually need to
advised
be
and informed,
advised
sir,
here.
that if you
The
choose
question
not
is
to
standard because
testify,
the person is usually
the jury will
represented.
be
So they're making sure the
advised that
counsel
they
has
cannot use
advised.
that against you? In other words, you have that right not to testify.
I'm informed.
Again, he
When you
doesn't have
make a
legal representation.
determination
There is no one to advise him.
about
of
whether
this.
to testify in this trial, I will further be asking you about whether anyone has made any threats or promises to you to influence your decision. I may also briefly go over your educational background.
As extensive as it may be.
Did you hear me say that?
No, I'll say it again.
At the appropriate time,
Me
What
fail
is-
English? That's
this-
impossible.
discussion more fully, I will also ask you whether anyone has made any promises to you to influence your decision on whether to testify. Did you hear me say that?
I'm informed.
And then I will also ask you if anyone's made any threats or coerced you in any way in your decision to testify or not,
And what's the significance of that?
so that I can make appropriate findings about the voluntariness, intelligence, and your, whether it's knowing, voluntary, and intelligent, your decision to testify.
So whether I give consent.
That's not the legal determination that I make. It is simply something that is your choice. I will honor your right not to testify. Obviously, that's a constitutional right. I will honor your right to testify. That's also a constitutional right. And the jury will be advised one way or the other. There's a jury instruction on that. Did you hear me advise you of all of this?
I'm informed.
All right. Okay, let's bring the jury out then. We can kind of tidy up the record and then we'll break it down.
Speaking of
Can we
tidy,
get exhibit, please?
I don't think we'll miss much if you just grift for
Jury
a
already
minute
coming
here.
out.
no, that they're gonna
Okay, so
tidy
the
up the
sit back
record
down.
with the jury and then go to lunch. So we're not going to
Subject
get
matter
the opening statement.
jurisdiction
So I'll do
still
it.
hasn't been
I'll do
proven
that.
for the record, Your Honor.
Shut your
for
mouth,
fuck's
dummy.
sake.
Should be proven at some point.
There's a
Subject
ruling
matter
literally
jurisdiction.
on the record, and it's proven, actually, with case law. It was written down, something you didn't even need to have. Judge just gave it to you.
I'm clearly going to need more whiskey for streaming. Yes. Fuck me, I just spilled half this on myself. I'm clearly going to need more whiskey now that I've spilled half of it in my lap.
No, you just need to get more flexible.
Yeah.
Thank you, everyone. Please be seated.
That's why I need you to fat shame me.
All right, then I'll turn to the state. Any additional evidence?
My arm has never smelled this good.
State has no additional evidence, Your Honor. We make a record as to the exhibits.
New from
Go ahead,
Papa Rabanne. Whiskey.
Your Honor, we believe that the court has admitted all exhibits that have been offered, with the exception of one prior ruling on Exhibit 6. I don't know if you want me to list them all by number or there are, it's 1 through 78, 1 through 178, but there are some numbers missing because we chose not to offer those exhibits.
Anything specific as it relates to the most recent testimony?
Most recent testimony with Detective Casey, we moved 177 and 178 and 175, 150, 151, 88, and 89. I believe those were admitted by the court.
That's my recollection as well, but for the jury, exhibits 150, let me start over. Exhibits 88, 89, 150, 151, 177, and 178. If I didn't receive them during the testimony, I'm receiving them now.
And 175, which was the still photo.
Thank you. Sorry, I had a scribble on my pad. And 175.
And 13 and 14. Those are the outliers. I apologize.
I believe those were received as well, but if I didn't
Objection, I
state
think
it,
they was already received.
I appreciate that. I just want to be thorough for the record. 13 and 14 were received as well. Do they have any additional witnesses to call at this time?
No, Your Honor, at this time, the state rests.
All right, thank you.
Yes,
And at this point, we are going to break for the lunch hour.
Jury's like, what the fuck?
I'm going to have everyone come back at 1:30. It's a little bit longer, at least.
Uh-oh.
That's what I want to do for the lunch hour today. So all rise for the jury.
He really needs that break.
Yeah, Sassy Brenna says so. Says, for the record, I was correct and I'm sorry. Yeah, it's your fault. She said there's no way that they're going to get to this opening statement before lunch and Nick's going to have to miss it. I'm so pissed at you, Jeff, at you.
It's all my fault. All your statements are belong to us.
Mr. Brooks, anything from you at this time, given the state is now rested?
What you mean?
What you mean?
Answer the question. Do you have any requests at this time now that the state?
What you talking about, Willis?
Request pertaining to what exactly?
I'll ask the question one more time.
Do you have
Do
any requests?
to
She
make
can't
at this
tell you
time now
what
that the
for.
state has rested.
I don't understand
Motion
what,
for a directed
what you
verdict.
mean by that. That's why I'm trying to get clarification.
I move for a bad court thing.
Simply asking the question. Do you have any requests to make at this time now that the state has rested?
I'll call you Brenna and you'll like it.
I don't know what I'm supposed to say to that. I don't understand.
Nothing. Shut the fuck up.
What would that be?
I move that I need more coffee.
I can't give you
don't
legal
know.
Make me some too while you're at it,
question to make a record.
bitch.
I'll ask you one more time. Do you have any requests to make now that the state is rested?
Make me a sandwich.
I don't understand.
Ask Judge Mummy.
All right, the other thing I want to do when the jury comes back out is you will recall I read instruction 101 at the very end of the preliminary jury instructions that just has to do with opening statements. I will read that with the caveat. It will just say that the defendant will now make his opening statement. The purpose of an opening statement is to give the parties an opportunity to tell you what they expect the evidence will show you so that you will better understand the evidence as it is introduced during the trial. I must caution you, however, that the opening statement is not evidence. So I'll read that. I think it's appropriate given that Mr. Brooks deferred his opening statement until the start of his case. With that, we will take our lunch break. It's 12:09. If you could be back here at 1:25 and be ready to go at 1:30 with your opening statement.
I got a question.
Go ahead.
Do I get to present exhibits and stuff like that too and admit them into evidence?
Oh my God.
At what point? are we talking
Holy
about?
shit.
Do you want to use exhibits that have been received during your opening? Is that what you're asking me?
No, I'm saying if I got my own stuff that I want to offer into evidence, which is a question I asked previously.
Do you believe
Yeah.
the state has all of those documents that they might be able to assist with? Or are they new documents?
I don't know what you mean by new documents.
Are they
New
from
documents?
discovery that you have?
Ooh, my favorite kind.
They documents of my filings and stuff like that. I'm sure they have copies of everything that I filed.
I guess without knowing specifically what you're referring to, sir, I did give you the admonition previously that you are prohibited from discussing subject matter jurisdiction during your opening statement. It's not relevant.
I'm not referring to the opening statement. I'm referring to things that I want to offer
Give
for
me an
evidence.
example, please.
I just did. I said I have filings that I want to offer into evidence.
That's too general, sir. I need a specific example so I can answer the question. What are you referring to?
My filings, everything
Which
that I
filings?
Am
filed.
I allowed to submit a
Every one
copy
of
of the Sovereign Citizen
They
website?
have to be relevant, number one, to the proceedings. Okay, number two, I don't know specifically what you're referring to. You can't offer testimony of yours through an exhibit. That would be hearsay. So you'll have to testify if it's your statement that you're referring to.
I'm not referring to I didn't say anything about testimony. I said
I'm being
filings.
general based on what I've seen thus far. So are you talking about during your opening statement or during the course of the questioning of the witnesses that you're calling?
Your Honor, with all respect, I just clearly said filings that I filed.
Mr. Brooks, if I understood, I'd
Does
answer.
Broncos Law School have a class on like court procedure?
I filed a number of documents. I think that's on the
Well,
record
without
that I
knowing what you're
filed.
referring to, then my answer is no. But again, well, I guess I'll have to wait and see as to when you seek to admit them, whether there's any objection or not, and whether they comply with all of the rules of evidence and the rules of procedure. That's the best I can tell you at this point.
I don't understand what you mean by that. They will only be relevant to obviously the matter. They
Maybe.
wouldn't
Sir,
be relevant to anything
I
else.
can't answer that anymore. We're gonna take our lunch break. It's 12:12. We'll see everyone back here at 1:25. We are
Judge getting hangry.
So I'm not allowed to offer anything in the evidence.
For the record,
Change the
I
chunky
never
milk.
said that. We are in recess.
So I'm trying to understand.
You're trying to understand because you don't and you won't. Okay, so what the judge was asking or prompting him for right there, just to let everybody know, is when the state rests, a very common motion in criminal trials is a motion for basically a judgment notwithstanding of the verdict or directive verdict, or effectively dismiss this case because the state has not put forth sufficient evidence to support the charges. We saw it in Rittenhouse. We've seen it in Curtis Reeves on this channel where we have that. These are almost never granted, but it's kind of just a matter of course that you would ask the state with a Hail Mary to end the case against you and then go home forever without having to put on any sort of defense. Just game over it. In this case, I'm not familiar enough with all of the charges, and my brain has not received enough information to know if they've proved every element of all of the charges. A competent legal defense, or not a competent, a capable legal defense in this case would have involved a team of lawyers diligently tracking when each of the elements of the case entered into evidence. Through testimony, through exhibits and stuff like that. And if they found any crimes that did not have all of the satisfied elements, they would bring that motion and they would focus on those particular things and say, we need to drop this one, this one, this one. They'd have reasons why they never got to proving this, because the state doesn't, they can prove their case through your case in chief. They can do that, but they have the burden to prove it before you even take the stand. So if you can get some knocked out, that's what she was asking him. Do you want to make a motion to try and dismiss these charges or any of the charges? He didn't understand that. Again, he's not a lawyer, and you don't have there's not like some duty of the court to make you aware of that. That would be on him to do it. But that's what that little pause was, where the judge is like, do you want to do this? Do you want to do anything? You want to ask anything? So just in case people were curious, I wanted to provide a little bit of education in the midst of all this fuckery. Speaking of fuckery, welcome to the stream, Aussie. How you doing, buddy?
Yeah, good. Can't complain.
That was a nice segue.
Yeah, no, it works fine for me. Missed the morning. Thank God I didn't miss his opening statement. I'm really looking forward to that.
Nick's going to miss it.
Oh, I hate you so much.
But no. Thankfully, I've got some sleep, so we'll be all good for the afternoon session. So set the alarm for 4 a.m. Saw that they were on break, and I was like, shit, I better get up an hour earlier. But so we'll get stuck into it.
Yeah, well, looks like, guys, Legal Vices here has a stream ready to go at 1 p.m. We'll do a handoff that's in 45 minutes, and anybody who wants to persist in watching this and see the opening statements and make fun of me for not seeing them, you can see them there. If you want to watch them with me, again, I'll probably watch them tonight on the nighttime show. Tomorrow is going to be a very chilled out nighttime show. We'll have a bunch of guests, although we'll see. Might have a guest tonight too, but we'll have a bunch of guests tomorrow. And I'll kind of announce that guest list as I figure it out. But Drexel will be in town, so should be a ridiculous disaster.
Oh, he's getting here tomorrow, huh? Cool.
Well, I think he might be getting here today, actually. So, but people are asking if I'll be back after teaching. I don't know what time I get home. Let me see. My class is only an hour, but I don't know if there's something else I have to do. Sometimes I have other obligations after teaching. Let me see. Yeah. I get done with teaching around 3, and then we got to get the kids packed up and get them back home. But I don't think I won't be starting up my own stream. I may join in with Jeff or something like that if I get home in time. So just there. When is the Bronca stream? That's Saturday night, probably 11 p.m. Central Time.
Oh,
so,
sweet.
Maybe 10 or something. I don't know. I just got to check with Lady Rackets and see when the best time for that is. But yeah, so that'll be Saturday if you want to check that out. As for right now, real quick, I do need to go ahead and finish this up, guys. The Birch Gold Group is the sponsor of this show. birchgold.com/knows. Look, the whole grift is pretty simple. People have IRAs and 401ks with a whole bunch of money sitting around in them. And that has to sit there for a long time. If you have assets that sit for a long time, they grow over time, but they also shrink over time due to market volatility. One way to hedge against market volatility and inflation is with physical assets like gold and silver. And they go, hey, it's hard to just buy gold and silver for a lot of people, but they have this pool of money that they can't really touch and is just going to sit there. Maybe that would be a good vehicle to use that to protect your investment. They're not talking about getting all of your IRA or 401k into gold or silver. They're talking about using it as a portion of a diversified portfolio. But really, like, whether or not that's the right decision for you is up to you. And what they want to do is give you the information. So all you do, birchgold.com/knows, click one of these green buttons. If you do it right now, they'll probably get back to you before I even go on break. They're that quick, as has been reported in the chat. And look, I can tell you a whole bunch of stupid stuff, like they've got an A+ Better Business Bureau rating. They've got thousands of positive reviews and all of that. But really, like, the reason I agreed to support them is, one, this might be a good option for people. But two, they support free speech. They support channels like mine. And they don't tell me what to say, what to do, or what not to say, or what not to do. So they're really just interested in getting the information out to as many people as possible about whether gold and silver are the right things for them. And that's a company with a purity of vision I can appreciate. So check them out if you want. Links in the description on Odyssey and on Rumble. And other than that, now that's done. Observations from today so far, guys? Of course, Aussie, you just got here. You haven't even watched anything.
I was watching while I was getting ready, but let's face it, you don't need to actually watch to know he was just being a complete nut of dickhead. So
yeah, absolutely.
Well, like we were saying, just what has he got to lose? He has nothing. I still think she should pull the first option, shackle and gag him at his chair. Just fuck prejudice, fuck everything that's going on. Say you obviously sending you to the bad boy room doesn't work. Sanctions mean nothing to you. We're going the nuclear option. We're chaining you to your chair and we're gagging you.
I think, while I agree that it would be funny, let's see.
I'm still waiting to see the taser cuffs. Like, I know that they can't really do that because it's being streamed, but I want him to go far enough that actually kicks off.
That would be great. Like, if he tried to, like, lunge at the judge or something, or the prosecutors, yeah, tase him. While I agree that binding and gagging would be funny, I think if you bound and gagged a criminal suspect today with the ability demonstrated to remove him to another courtroom and mute him, that I would make an argument that was prejudicial if I were his attorney.
But he's been sent there multiple times and hasn't learned his lesson, hasn't modified his behavior.
I know, but I think the imagery of binding and gagging a defendant in a courtroom when you could send them to an adjacent room and mute them, effectively gagging them and binding them, but without the physical restraints, I would make the argument on behalf of that criminal defendant that was a prejudicial infringement of his rights, prejudiced him to the jury, and was completely unnecessary today, when they've demonstrated the ability to move him over there and commute him. I mean, I'm not saying it would work. You're going up against an existing precedent. We have stare decisis, which would favor that existing precedent. But I think if you're going to argue that the technology changes that the judge has been using are acceptable under that case, then I would argue that maybe the old way of doing it is not acceptable. And I think that'd be a valid argument. And it'd be interesting to see how that panned out, but I think the judge is being very cautious, knowing that she could do it. But if she does that, to me, that's an appeal point. I don't know that you win on it, but I would make a really strong argument that that's a mistrial. So,
but at least he wouldn't know to make that argument.
That's true. But that's true. But he would get an appellate lawyer. His appeal will probably be handled by the Public Defender's Office of Wisconsin's Appellate Division, and they would make that argument for sure. So, but man, it would be funny to see, though. You kind of want it. Kind of want it a lot.
Kinda, yeah.
Because he's being really insufferable today. But I think Peter was right. He knows that the end of the prosecution's case is coming. He got more and more belligerent as it went on, because now he's got to present the case. And as every phase of the trial ends, it's closer to him going to prison forever and never having as much power as he'll have in this moment. I mean, this is the most powerful Darrell Brooks will ever be. He's got some media attention. He's got a courtroom that has to deal with him and has to put up with everything he says. They have to listen to him, and his bullshit just gets to work. It's not going to work in prison, though. Like, you mouth off to a guard like that, and they don't go, Mr. Brooks, we have to respect your ability to mouth off. No, Mr. Brooks, fuck off. You're done. And you get a little punch, and then you get back in your damn cell. So,
more to the point, I'm waiting for him to be in the shower, and Bubba drops a soap and says, "Pick that up for me." And he goes, "I'm a sovereign citizen. I do not respect your authority."
He's going to navigate that land boat right into that land ass. That's going to happen.
See that's where we need Drex to get the authority in the community.
So,
you will respect my authority.
But see, that's the question I have. I mean, ordinarily, someone like Brooks would be deleted very, very quickly in a Gen Pop situation. But has he taken this soft sit bullshit to an extreme where he would become an in jail hero of sorts?
I don't know. I have no idea. He's got the conflict of, he killed like a kid and some old people, and it's kind of like a bitch crime. And if he kept with his attitude that he has in the courtroom, he would run afoul of certain people. But, maybe not. Maybe he'll maybe he stood up to the man. Maybe he, did it in his way, like Frank Sinatra, but dumber. I don't know. I don't know the psychology of prisoners that well to comment on it. I do want to say something happened that I just saw in the chat. Where was it? Fuck. What did I just see? I saw something that I wanted to comment on, and I can't remember. Oh, wait, was it up here? Shit. I don't know. My brain just broke. Oh, wait, no, there it is. Lady Rackets has dropped a new video on her YouTube channel. If you want to go check it out, Lady Rackets' YouTube channel, The Real Lady Rackets on YouTube. She dropped a new video today. I haven't seen it yet. I've been on stream. I've barely seen her. She was sleeping when I left. Okay, Jeff, do you want to be fat shamed now?
Oh, yeah.
You do? You sure?
I paid $20. Yeah. Well, my money's worth.
Are you sure that about the fat shaming as you are about every cheeseburger that you shove into that disgusting gullet of yours?
I am.
Can you, Jeff, when you
hang on,
will you do me a favor?
I'm gonna pull out my lollies while I do this.
Yeah, that sounds good. Will you do me a favor? And when you die, obviously soon from a coronary or some other unrelated issue, can you ask God why he printed your body on silly putty and stretched it out? Could you ask him that? That'd be a good question. I know like your people believe that you'll get your own planet when you die, but did you realize that it meant that you would be the planet and that other Mormons would be orbiting you? Like that's how that was going to work? Do you get to practice like the polygamy thing with multiple wives because they're stuck in by your gravity and they're just following you around forever helplessly because you're such a giant degenerate pile of trash? Is that how that works?
That's how that works.
Okay. I just wanted to check. I mean, I was just curious. I don't want to fat shame you though. That'd be horrible.
Facts are facts. I got women's tucked under the folds of my belly.
Make sure you put some bamboo or some reeds in there or something so they can breathe. Okay.
It's the corpses I like. They don't struggle.
Oh my God. Christel Picciano says, would a white person get away with that megalomaniac spectacle? Yeah, I mean,
thank you.
It's you're welcome. You're welcome. Thank you for indulging me in my fetish. I think the way the judge is treating Darrell Brooks is less about race and much more about an unrepresented party with literally nothing to lose. There's no punishment in Wisconsin that she can do to him during this trial that is worse than what he is already going to get and what he's already in. If she holds him in contempt, he will just go to his jail cell that he's going to anyway. And he may actually get a delay of the trial, which would be what he wants. There's just nothing you can do. You can't order the bailiff to kneecap him when he walks by. That would be great. And I think Brooks knows that. So the judge is to tread this fine line where she knows she can't do anything to him other than remove him to the other room and try to get this trial done and try her best to let him go to prison as he deserves. So, Excelsior says, just how far can he take this non-responsiveness? I'm assuming there's got to be some kind of mechanism for dealing with a pro-per defendant just simply refusing to engage with the court's question. I answered this in chat, but I want to answer it again. He was responsive to the court's questions. Him saying he was informed, that is enough. It's not the court's job to advise him. The court asked the question that way because he's typically would be advised by counsel, and they want to make sure that counsel has advised him that the counsel doesn't get to control the flow of trial. The counsel can't decide whether or not he testifies. They can make recommendations, but ultimately the decision is his. That's the point of that colloquy. Do you want to testify at trial? My counsel says I can't. Well, do you want to, though? It's not up to your counsel. So that's why they asked the question in that form. Him saying he's informed of those things, of his rights, that's sufficient for the court. Ryan PD 911, Judge Cucker, formerly known as Darrell Brooks, we found a name he thinks he identifies as. Bebop Daft Dragon says, I want to cut his face off and eat it like KFC fried chicken.
Me too.
Okay. Okay. Mediocre Didge. How are retards like Brooks able to survive so long? This is the downside to modern medicine and welfare. Survival of the fittest goes by the wayside. But you don't think his rap video made him plenty of money? Math Boy Fly is rolling in it. I don't know what you guys are talking about.
Oh, yeah. The royalties just be rolling in.
He's going to need some commissary, I'm telling you.
Kay Steiny, first ever Rumble rant. Hey, thank you. I wonder what Elaine Breedoff's ratio of objection to overruled is compared to Brooks. I think she is doing better. I think she's doing better.
I would actually like to see the breakdown on that. I really would.
That would, yeah. Hers were really bad, especially for such an experienced attorney. Hers were really bad. Blue Varo, Nick brings a whole new meaning to home economics. Today, kids, we're going to learn how to distill whiskey. I'm going to bring on a whiskey distiller sometime soon, and we'll talk about that process. I actually don't really, I know very basics of it, but not anything in depth. So we'll bring Sellerman's Folly. We'll bring him on soon. He's a distiller out of New York, like a small town, an independent small time guy who's makes his wares. I have a couple of his bottles. I don't think I have them right here with me, but Zonoman Empire says, Nick, I just found out I passed the New York bar. Thank you for all the streams that got me through studying. Hey, congrats, brother.
Yeah, congrats.
That's awesome. Now find some way to
pay back your loans
without hating your life. Well, that too. Princess Liana, did Brooks change his name in prison? Why does he object to the name every time? It's sovereign citizen nonsense. The name that's printed on the paperwork is Darrell Brooks in all caps. So when people say Darrell Brooks in court, his brain is saying that's all caps Darrell Brooks because that's what's on the paperwork. And I don't identify with that because that is the name of a shadow corporation created by the United States government on the moment I was born by putting that name on my birth certificate. But that's not my name. And yes, if that sounded like a lunatic reasoning, yes, it is. But that's the argument that they make. Dashner says, hit the plus button like it Peter behind as he plows you. Like it's Peter Tragos behind as he plows you. Okay, got it. There you go. Ladies, especially hit that plus button in the on the Rumble app. Make sure to help all those likes. Like they really do help push the video to the top of the Rumble playlists and help more people find the show. So thank you for that. We did pass 85,000 subscribers here on Rumble. We are on the train to 100K.
Wow.
And then we're on the train to 1 million after that. And it's going to just keep rolling. But it really helps when you guys push that plus button or that thumbs up if you're on mobile. Please do. Corn Pop for President says, touch grounds. On paper, objection. The most banned
Die.
queen. Gonna give this a shot when Rackets ends at noon. Well, 1 Central. Anyone who prefers to discuss this using the Rumble chat can join me here at noon. And she's got the Rumble link, which I can share in the Rumble chat for people who want to check that out. I'll share it in the locals chat as well. If anyone wants to go join her there. The most banned queen, a frequent commenter here on the show. You can check out her discussion. Project Calm TLDR. We have enough money to bury you complete, or we have enough to bury you completely. It is all admissible. Open your mouth and it comes in. Jay Burton X. It's fun to listen to Pink Floyd's The Great Gig in the Sky while the defendant, formerly known as Mr. Brooks, testifies. Torched Medic. Your Honor, we find the defendant guilty. We ask, though, can we bring the death penalty into play for this one convict to make the world a better place? Damn.
I'm going to pop out for about 10 minutes and get stuff ready for 3 a.m. my time.
Oh, jeez, it's early. Engineer Nick, I found a website including all of the arguments for this Sovsit bullshit. Educationcenter2000.com. If you want to review it on stream, except for value dumb statements. Maybe I'll bring this up. I'll pull it up, but I'm not going to bring it up on stream tonight. Let's see. Okay, and I just got oh God. I just got looks like some confirmation. Andrea Burkhart may join the stream tomorrow, guys. So very cool. I haven't talked to Andrea, I think, since pretty much the Depp trial. It's been a while. And so I'm looking forward to having her on the stream. She offered to come in, but we were already at lunch and I wouldn't be going any longer. So I didn't want to say, yeah, pop on for 10 minutes. But yeah, so hopefully tomorrow we'll have her on. The most banned queen says chat on my app isn't working very well. I was reading in on EOF that Rackets was ending at noon. I thought I'm streaming now. I question my life choices. I wish Brooks would. Chaos Drive 50. This is black privilege right here. Also, whoever said black people are still being oppressed, keep in mind, if this was 1916, he would have gotten done, i.e. Jesse Washington. Damn. Leia just had someone call in for a consult who said they were going to try to represent themselves. I wanted to tell them to watch this trial to see how that goes, but bit my tongue. Yeah, it doesn't ever go well. It doesn't ever go well. Aussie Overlord, is it lunch already or a cool down break? That was a cool down break, but it was right before lunch. So thank you.
You know, that was before I was trying to work out whether or not I was actually going to get up an hour early or not.
Well, sorry you got up early.
All good.
Voidir, can or should the state bring up Darrell Brooks' in-court behavior in closing, or is that not proper argument, facts, not in evidence, etc.? That would be improper. The jury can make their own determinations about the. Let me roll that back. It's not like automatically improper to reference his evasiveness or something in court. I would hesitate to do so. The state has no reason to do that. It would be ill-advised and unwise. They can just stick to the facts of the case that they've presented. They don't need to appeal to the jury. The jury has been sitting there dealing with this shit the entire time. There we go. Freighter J says, thank God this didn't happen in Illinois, because his legal arguments would probably be convincing for your average Chicago area juror, although Kim Fox probably wouldn't have charged him. Loose Cunt 79 says, Nick, I would feel blessed to have this judge and prosecution if I found myself in any legal trouble. His chances on appeal were nil. Now they're non-existent. Fair and balance. Want to ask you all a question. Do you think this bitch should be done with this hood rat? Photo record, I'm done with him. Gonna ask you again, miss me bitches grounds. I'm a humming being objection. Human being. Oh, objection. Good luck with this. What's up, Farron? Thanks for the hood speak. That was the whitest thing you've ever done. Tarkina 53. That is why you have a lawyer, you dumbass. Thanks for covering this morning, Nick. Hey, you're welcome. Bald Eagle says, how unfortunate would it be if all of Brooks's witnesses caught COVID before testifying? Il Sarto, why didn't he ask for subject matter jurisdiction when she asked if he had any requests? What do real lawyers request when the prosecution rests? I covered that. We talked about it, but basically a motion to dismiss the charges against him for lack of sufficient evidence. But he can bring up subject matter jurisdiction whenever he wants, normally, but the judge has ruled on it with a filed ruling. She doesn't have to rule any further on subject matter jurisdiction unless new evidence or a new legal argument from evidence that's been admitted manifested to suggest that he wasn't driving like in Wisconsin, but instead he was driving in Illinois. Like that'd be that Waukesha isn't low, like that his car actually hit people in a different state instead of this one. That'd be the only way he'd be able to get around jurisdiction in this case. But you can always raise jurisdiction. Let's see. Next. Dee Dee Hine. Nick, will you be on tonight to discuss the opening statement from Mr. Brooks? Probably. We'll see. We'll see. I'm going to be on tonight. The question is whether I'm doing that or if Drex is going to be on or something else. I'm not sure yet. Fair and Balanced says, Your Honor, want to ask the court to let me enter into evidence my most recent rap album that was playing when I was in my ride. Objection. Don't mute me, bish. Fair and Balanced also says, Your Honor, I want to ask if I can lay a beat during my opening statement. I would respect this. I would respect this. I'm going to need my equipment, Your Honor. What do you need? 2 turntables. It's a beat from my new rap album that's dope. Quit being a bish. Let me throw it down when I open. Eminem ain't got shit on me. Horror Amarada. Hey, Nick, my mother's in the ER with what appears to be a heart attack. If you in the chat could offer some thoughts, prayers, and baby goats, I'd appreciate it. Yeah, Horror Amarada, I will definitely be praying for her swift recovery. Hopefully it's not. Hopefully it's just like angina or something else that is not as serious as a heart attack. Xenokov. Tell Vices it's day 11. He labeled his video incorrectly. Well, tell him when he gets back. All right, next. Holy shit. The Drunken Rock. Is it the Drunken Rocky over on Odyssey says, join my live stream tonight on Odyssey at 9 p.m. Central. We hang out and laugh and shit on the internet. Periodically, I spurg out on my guests for derailing the flow, drinks, and autism. So that's the Drunken Rocky on Odyssey, guys. Give that a check. Johnny Apocalypse says, may Brook's sentencing lead to all the prison raping and dropped of soap. Also, to your locals, you can send chats by pressing the money button next to the paper airplane button and buy some coins to tip. You can do that. That is an option. Sheepsidian. Brooks is exemplary for the phrase, black people can figure out how to get online, can't figure out how to get online to get in line. Okay. Mooger Fruger 98. Legal Vices is the best. A true bishop for the Pope. Lagardicus says, at this point, I just want them to activate the shock shackles in front of the jury and on camera. I agree. Like just once, just give us this one. Just shock him a little bit. Even I would take not in front of the jury, but just on camera. What do you think it's got to do? What do you think he's got to do to get shocked?
I'd like to see him take a swing at a bailiff.
That'd be
maybe
good, yeah.
Maybe throw his Holy Bible that I'm not entirely convinced is actually a Holy Bible.
But it's court provided, so I think it is.
Oh, is that court provided?
Yeah, I think on the binding, it's got like a big W or whatever. Like, so it's the state's Holy Bible. So I think
that kind of makes it even worse. The fact that he's been pretending to read that.
Yeah.
Like, when he opens a page, his eyes aren't moving across that page. He's just staring at it. So,
he probably
he
probably put nudes of the judge in the, like, you know, like when you would hide like a comic book in a textbook.
Yeah. No, I'd like to see him take a swing at a bailiff. I really would. And then I'd like to see him get his ass whooped on live stream.
God, that'd be funny. Barrick D, yo, Nick, why don't courts stop writing names in all caps to blow the minds of these sov sits? What is the point of all caps? Dude, the point of all caps is just clarity and uniformity. It's a simple thing in your caption to have everything be capitalized that's important. So the name of the person, the charge filed against them, or the type of matter that they have. Typically you would have all caps on the county and state courts that you're in. You know, all of those things are capitalized, again, for clarity and a lack of ambiguity, and for probably prominence as well. But the reason they don't stop is because if they didn't have them in all caps, the argument wouldn't change. That's just the one thing they say. Well, it's in all caps. if you had it like say in normal with the first letter being capitalized and the rest of the letters not being there, they would still say they don't recognize that name because it was a state provided name. It's from a state document. Like they wouldn't change it. Their argument would just shift slightly on reasoning, but not in
It'd still be
direction.
insufferable. Yeah.
Yes. Let's see. Barron's guy says, after that fair and balanced chat, I don't believe she was truthful about never having black dick in her mouth. Wow. Unrelaxed says, what's this button do, guys? And he also says, imagine these virginal jurors thinking, is this how every court case is? Teabag 89 says, rate my bottle, fam. We've got Dalmore. Ooh. Dalmore King Alexander III. I've never had it. I like Dalmore, though. It's probably good. Floppy Turtle says, I really want the bailiff to accidentally hit the button for the zap shackles. Johnny K says, I retract my statement. Fuck this guy. Taser, taser, taser. Oh, and he's retracting this statement. They didn't even need this testimony, so fuck him for extending this case to prove a point and for what a huge shit show. So he retracted that. Probably good. Let's see. Next, we've got Ryan PD 911 says, rope crafts, bring the smoke. This case gives a whole new meaning to witness impact statements.
Oh, God. Yeah, what do you reckon's going to happen there?
I think that was a joke about them getting hit by cars.
Oh.
The victim impact statements at sentencing are going to be, they're going to be brutal. Brutal. Unrelaxed says, is Brooks grifting his own music video at his sextuple murder trial? He should. Always be grifting. Angry Medic 5, did this fucker just say counteroffer? Yeah, I was a little confused on the counteroffer thing. In theory, Brooks could actually plea out. He'd have to ask permission of the court to change his plea at this point. He'd have to do that. But he could do it. The court would, man, if you're the court, you'd probably grant that one. But I think the plea offer that he got was, I mean, prison forever is the plea offer he got. So they would have to come down from that position. And I don't think they would. Floppy Turtle says, got to get that Wiscusy. And that is the end of the locals chats, I think. And then I got a couple more over on Odyssey here. Smithwick says, what is the in personam jurisdiction he keeps arguing? Well, okay, so in personam jurisdiction is jurisdiction over a person. I haven't heard him say in personam. He may have while I wasn't listening. He's usually arguing subject matter jurisdiction, which the subject matter jurisdiction is this the appropriate court for the type of law? Is it a district court for the purpose of criminal law within a state? That would be one thing. If this was family court, this would be possibly an inappropriate venue or an inappropriate. The court may lack jurisdiction over that. It depends. If it was bankruptcy, the court would definitely lack jurisdiction over that because bankruptcy is tried by the federal bankruptcy courts, for example. So that would be subject matter jurisdiction. In personam jurisdiction is, does the court have authority over the person? Are they from another state? Are they in another state, et cetera, et cetera? In personam jurisdiction gets really, really simple when the person commits a crime within a state, particularly a felony. That court then can extend its jurisdiction over them almost anywhere on earth when the felony gets bad enough. And his definitely qualifies. I hope that helps answer your question. Roy Rat says, Waukesha County Jail Bible, all pages ripped out except Ezekiel 23, 19 to 21. There she lusted after her lovers, whose genitals were like those of donkeys and whose emission was like that of horses. And Cenk Uygur is immediately aroused.
Key fact. People keep going on about how men like to be hung like horses. A 200-pound guy only needs 4 inches. You're welcome, fellas.
Oh, if it's proportional to a horse, is that what you're saying?
Yeah.
Okay. I was like, how do you...
Yeah, you stopped for a second there. That was good.
Did you walk around with a ruler there? With these metric inches? I was very confused. Very confused by what just happened. Glad you clarified. Fair and Balance says, never had chocolate tea. Don't want it. Lactose intolerant. You wish, bitches. and call me by my street name, Goldie Hoodlocks. Okay. Thank you, Farron, for that one.
Oh, dear.
KMWIL 275. What if they pronounce his name Darrell? Darrell? Would he acknowledge versus Darrell? They in the interview they kept calling him Darrell instead of Darrell. So that was weird. I don't know why they did that or why that's changed. But yeah, they were calling him Darrell in the detective interview. But no, the answer is no. This is just a bullshit thing that sovereign citizens do. They think it's a magic trick to get out of their crime. Like that's the whole point. He goes by Darrell Brooks everywhere on earth. He probably has written his name in all caps somewhere. Like this guy is not a serious adherent to the capital letter thing. He's just doing it because it's magic to get out of prison. Jay Winkler says, what the fuck is this value for value thing? It's oh God.
Yeah, there's a few different theories on that. I mean, I had come across a legal principle about accepting it for value as you're accepting a document with all imperfections. The second part of it, returning for value, no fucking clue.
Yeah. Yeah, that's the thing. And he doesn't have any, he's not actually even accepting or he's accepting things because they're being given to him, but he's not returning anything else. So I don't know what his return for value thing is. We'd be speculating. So by Tackett agreement, I'll just say it's retarded. Seed and Feed says, how do these lemon bits work? Testing. Limestone says test. CSMYK says jection leading. Seed and Feed, let me ask you a question. Seed and Feed, go off. Keffel's mom. Seed and Feed, this is gold. Fredrickson, is this bitch still pretending he is not the defendant? B Jams, I really hate this rigger. I don't know that he's ever worked on an oil rig, so I'm not sure if that's, might be a misunderstanding of his job classification. Do you have your stream labeled properly as day 11, Jeff?
It could be.
Not.
I have day 10. I guess I better change that.
Yeah, that was the chat. The chat was trying to look out for you there.
That's why I said maybe. I wasn't sure.
Read those. Scan to Hero says shit post and B Jams retracted, but I really hate this N word. Damn. Okay. So that's all the chats we've got over on Rumble, Odyssey, and Locals. I've got 10 minutes left to discuss things. But if you want to fire up your stream, Jeff, I'll just go ahead and start directing people there now because I have no particular reason to stay. The court's not coming back before I leave.
True. All right. Well, give me a couple of minutes here, and I'll be there with you.
Yeah, guys, make sure you. Oh God. Okay, so that's the video she posted. Okay, got it. Make sure you check out Legal Vices and Aussie Overlord on YouTube. And do both of you have Rumble channels?
I'm on Rumble.
You're on
Rumble and Locals.
I have a Rumble thing, but I don't have it all connected and hooked up yet. That's this weekend's project.
You got
okay. Well, in that case, if this is going to go out on YouTube, because I know it's going to piss off a few of the chat, I'll try and work out how to simultaneously stream your stream onto my Rumble so people can go and watch it there if they don't want to support YouTube.
There you go.
Well, they better support me on YouTube. Grift. It's my grift. They better support me on my stream.
So guys, make sure you check out Legal Vices over on YouTube, Aussie Overlord here on Rumble as well. They've been fantastic guests when I've been able to have them on this week, and they've been picking up my absolute failure of being able to stream every day of the trial, which I hope to always do, but sometimes I just can't. Like today when I have to leave a little bit early due to other obligations. And finally, The Real Lady Rackets over on YouTube is my lovely wife who's started posting content. You can go check it out if you want. It is not like my content at all, but some people might find that very, very refreshing or just interesting in a completely different way. So please do go give her a little view and maybe a nice comment if you like her videos or whatever. I think she's swell. With that, Jeff, let me know when you're up and I will. We'll get out of here.
Almost there.
Ward says grift donation. Thank you. Oh, and let me grift the most important thing, rekietalaw.locals.com. If you join my Locals, the live chat that we have going here on Locals is going to persist, even though I'm not streaming. So if they're watching the trial, you can still participate there as well. And let me tell you, it is a degenerate and beautiful place on the internet, a place of freedom, a place that reminds you of what it used to be able to say just about anything.
I'm going to pop out here and then I'll text you when we are live.
Sounds good, buddy. I'll talk
See
to you
y'all in
then.
a minute. And hope you come back after you finish teaching. We'll probably still be here.
Yeah, send me the link and I'll try and make it.
Will do. See you in a second.
Ward also says you're welcome. Oh, thank you. Thank you very much. Let's see. What the hell?
Day
Okay.
11.
I thought I had the link already. But yeah, make sure you check out my locals page. I've been getting comments again on my YouTube videos like, oh, you're slacking, not posting to YouTube. I'm like, guys, I'm suspended. And they're like, I had no idea. It's like, well, if you followed me on locals, you would always know what's going on because no matter what happens on any other platform, I post to locals where I am streaming or where I am guesting. And again, we have this ongoing live chat 24/7. The community is there. We're pushing towards 5,000 supporting members in the community. And we're over 4,400 now. So we're getting there. We're getting there. And at 5,000,
pretty close to 5,000, aren't you? All right.
yeah, we're at I'm checking the most recent updated number, 4,437. So and I'm gonna tell you at 5,000, if you want to be in on the fun thing, that's gonna be those 5,000 people when it hits. So that's the plan. It's going to be like if you join at 5,001, you might be missing the boat on that. Not to put any pressure on anybody, but yes, give me money. All right, looks like Jeff is live over on Legal Vices on YouTube. Go check it out if you want to continue watching with the same kind of people. There are some other places to watch the streams, but are there better places to watch the streams? That's the real question. All right, guys, thanks. I got to go teach the Constitution to some kids. I'll talk to you later. Aussie, thanks for joining me, buddy.
All right, I'm setting up a simulcast on Rumble. I've just dropped the link in chat if people prefer to watch on Rumble. Otherwise, yeah, we'll see everyone over there.
Sounds good, man. And I'll send you a link tomorrow as well. So talk to you then. All right, peace,
Cheers.
guys. Peace. Oh shit, I got to play the outro. Play the outro.
Oh, he drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some law-splaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes madder, raging at idiots from Twitter and Darrell. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an Ardbeg, a Balmore, a Lafroig, the spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter, as we hear law-splaining tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, the guests are all plenty folks, from Doug T to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. So pour out an Ardbeg, a Balmore, a Lundbrook. Spirits flow as the one should get unemployed. So pour out a glass for the team post on Twitter as we hear Lost Painting tonight. From the wide shores of Nairn to the hills of Glenlivet, there's no one who explains the wrong better than Nick. So pour out a glass for the one